I think we have one attorney on his side.
Still waiting for two more to come in, sir. Zoom has been running a little slow today, so it takes a while for the attorneys to come in from the waiting room. So sorry about that. One more now. Okay. If you're not in the first case, please stop your video and mute your microphone for now. And when your case comes up, turn everything back on. Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. We'll begin this Zoom session with the case of United States versus Shea. And Ms. Tarleton, we'll hear from you first.
Thank you, Your Honor. Good afternoon, and may it please the court. Jackie Tarleton for Kevin Shea. Your Honors, we've discussed in our briefs why Mr. Shea is not dangerous and no conditions should have been imposed on his release. But I'd like to spend the bulk of my time today addressing the procedure district court should follow in determining whether any release conditions at all are appropriate, and if so, which are authorized by statute. We are asking this court to follow the straightforward and correct statutory interpretation of the 11th Circuit as set forth in United States against Crape 603 F3rd 1237. First, the Adam Walsh Act requires immediate discharge of detainees who will not be sexually dangerous to others if released unconditionally. And that's from 18 U.S.C. 42E1 and also from the court's decision in Wooden. Conditional discharge is only authorized for those detainees who require medical care or treatment to keep them from being sexually dangerous. That's from this court's decision in Wooden at 609. If a prescribed regimen of medical, psychiatric, or psychological treatment or care is required to keep someone from being sexually dangerous, the statute sets forth the process that should follow, and that's at 4248E2. First, the regimen should be prescribed, so it should originate from medical professionals or treatment providers for him, for the detainee. It should be then certified to the court by the director of the facility or the warden as appropriate, and it should be found by the court to be appropriate. This is all set forth in the 11th Circuit's well-reasoned decision in the United States against Crape, which explains that the text is clear and that no other statute authorizes any additional conditions of release to be placed on detainees. 4248 was enacted after the supervised release statute at 3583. And so
Ms. Tarleton?
Yes, Your Honor.
Let me just interject at this point. I thought that the issue we're facing is whether your motion or the government's motion for release should be approved. In other words, you filed a motion on behalf of your petitioner to be released without conditions, and the government filed a motion to be released with conditions which were attached to the motion. The conditions were lengthy, and they were a regimen, a prescribed procedure that was certified to by the warden, and that is attached to the government's motion. You agreed that if conditions were to be opposed, those would be appropriate. So the whole issue presented to the district court was whether release should be conditioned or not conditioned. But there was no challenge to any provision of the conditions. Those were developed at Butner and were certified to by the warden. And the judge found them appropriate, but that was not an issue presented to the court. Aren't we really faced with a single issue here now of whether this man should have been released on conditions as proposed by the government and certified to by the warden, or whether he should be released without conditions as petitioned by you.
Your Honor, we believe that our challenge is fairly encompassed in our request for unconditional release. But indeed, this court is bound to determine the legal standard to apply to those conditions that were imposed. And in this case, we don't believe that the district court had any statutory authority to impose anything beyond a treatment regimen. And contrary
What was
to the
imposed? What was imposed beyond the conditions proposed by the government? The government proposed a lengthy list of conditions which were developed by the staff at Butner and certified to by the warden. And as far as I can tell, maybe I'm wrong on this, those conditions were not changed by the court, were they?
The only condition that was added was actually requested by Mr. Shea that he.
Yes, that's right. And that was added. So setting that aside, nobody's objecting to that. Setting that aside, the court didn't address or add to the conditions proposed by Butner and approved by the warden and advanced by the government.
I'd like to clarify, Your Honor, the origin of those conditions. At JA 59, the government represents that these were developed by the warden and the probation office and doesn't make any mention of treatment providers. And in fact, when Drs. Smithson and Barnett were asked at the hearing, they each had reviewed the conditions, but neither said that they had been involved in creating those conditions. We cited in our reply brief 2 cases, Williams and Simpson, that have nearly identical conditions to those that were proposed for Mr. Shea. And in fact, the government never represented that this was in fact a regimen, a prescribed regimen of psychological, medical, or psychiatric care or treatment.
Well, sure it does. There's a certification on page 72. And the certification said it was, the warden says, I find the prescribed regimen of medical, psychiatric, and psychological care or treatment that has been prepared for Mr. Shea is appropriate, and that he be conditionally released. And in the previous paragraph, he suggests that this is this list is a result of the treatment he received at Butner. You know, for us to open all this up when none of this was challenged below, these were conditions. And not only that, didn't you approve these actual conditions in your response conditionally?
Your Honor,
you said if conditions were attached, they were appropriate. Didn't you say that below?
The lawyer in the district court asked for unconditional release. And if conditional release is all the court would approve, agreed to conditional release. But
they agreed to the conditions.
To the conditions proposed by the government.
Yes.
But that was an alternative argument after their argument that Mr. Shea should in fact be unconditionally released.
But that's precisely my point. In the district court, your position was he be released unconditionally. If he's going to be released conditionally, you agreed that the conditions were appropriate. Now that ended that discussion in the district court. There was no challenge to any condition except, as you pointed out, the one added. And so I find that there's a little bit of sandbagging going on in the sense that all of a sudden on appeal, you read the petition, you read the condition, you say, oh, some of them are, I can't figure out why they're relevant. Well, I must say I can find out why they're relevant if that's our course. But these conditions are imposed very carefully. It takes medical people to understand why you have to do this or you have to do that. As you read the conditions, you can tell that. So I'm still questioning what's the issue before us. I thought the issue before us is whether he should be released without conditions.
I think at worst, Your Honor, if this court were to believe that we did not preserve this argument below, that this court would not decline to review, but it would in fact review for plain error. And we believe here that the error
You can't do that. Yeah, this isn't not a question of raising it. This is a question of actually agreeing to them. This is stronger. You agreed to these conditions below. They were appropriate and they were not challenged, except that you wanted to add one and the court added it.
Your Honor, I believe that this court is bound to follow the statute, and if there's no statutory authority for the district court to impose these conditions, that this court is bound to send it back and allow the court to evaluate these questions under the proper legal standard. I don't believe that these are
as I view Judge Niemeyer's question is, I'm not sure I'm following it fully, but I'm trying to understand. It seems as though, from his perspective, what your situation is that you were saying no conditions. But in the alternative, if there are conditions, then these conditions are fine. And I think what I interpret that to mean is your argument is he shouldn't have conditions. And but at the end of the day, if you rule against me on that, then I wouldn't have a problem with the conditions. Or maybe there may be further argument, but those are two separate things. If I'm understanding, I guess I read it was that the warden is not free to add conditions to a discharge and then call it a regimen of treatment. Or is that your position?
Our position, Your Honor, is that this regimen of treatment should originate from medical providers. And then there's a stage at which the warden certifies them as appropriate. And then the district court has an independent obligation also to determine that they are appropriate. Here, yes, Judge Keenan?
Well, these cases are always difficult because it puts us, the court, and the warden, none of us are experts on this at all. I mean, he doesn't know what regimen should be used other than his experience as a warden. I'm pretty sure of that. We don't know, which is why these cases are really difficult. I thought the issue here was a question that arose from, well, is this guy still suffering from a mental condition, a mental illness of some sort, for which it would require you to be able to, which then authorize the court then to move forward. And that probably the main question here is there anything here that says this guy is suffering from mental illness? And notwithstanding, he has a history that nobody can defend. I mean, if you look at it on history alone, but the court law is pretty clear. It's not on history. In the last 4 years, he's been doing something else. And so then it turns on not whether or not you put conditions on it and then call it regimen of care. Is really a question of, is he suffering from a mental illness that would require this to happen? Is that more or less where, am I viewing that anywhere the way you do?
We do also make that argument, Your Honor, and that's we completely agree that neither Mr. Shea does not suffer from a serious mental illness today, and he also, as a result, would not be sexually dangerous if released.
So if that's true, then how could you agree to conditions if he's not suffering from a mental illness? Even if you did agree, how could you do that? No one can do that if he's. That's like saying a guy who is not guilty should go to jail for 10 years.
That's exactly right, Your Honor.
You don't have any proof at all that he's guilty without even going to trial or anything on it. But that's what I kind of viewed it as, the really essential issue. As I said, if you look at the history of it, if it was just history, you couldn't even walk in the court on this. I don't see any possibility of it based upon it is indefensible. But that's not the inquiry. The inquiry from the case law is you got to see if at the time of this hearing, is there some evidence of this mental illness, from my perspective. But that's just the way I'm viewing it.
That's exactly right, Your Honor. Yes, Judge Keenan, excuse me.
Okay, Ms. Tarleton, thank you. I've got a couple questions. First of all, I'm understanding your arguments are being made in the alternative. Is that correct?
That's correct.
Okay.
Thank you.
And then second, I'm interested in these conditions. Is there anything in the record that shows us the boilerplate conditions applied to everyone who comes out of Butner on conditional release? And the reason why I'm asking this question, we had this experience in the Western District of North Carolina. You may be familiar with our McMiller case. And those were boilerplate conditions, not tailored to any specific individual. The court was just issuing them irrespective of the person's record and background. So I'm wondering, does the record show whether these are boilerplate conditions, or do we have any way of knowing that looking at the record in front of us?
Your Honor, that's exactly one of our concerns. And at page 14 of our reply brief, we specifically cite to two cases, United States against Williams and United States against Simpson, where the conditions are very similar to those that were imposed against Mr. Shea.
Right,
And
excuse me, but does the record show that, I know there may be a couple other cases where the conditions are the same, but does the record show that these are boilerplate being just issued automatically in every case? Do we know that or not from the record?
Well, Your Honor, I would point the court to Joint Appendix 339 in addition to those other conditions where government counsel asked Dr. Smithson if the treatment team was involved in creating the conditions that were proposed to the court. And she said yes, and that they were previously involved in proposing conditions to use for a particular person, which suggested to me that there was some involvement by the treatment team in a generalized set of conditions, but that there was no effort, certainly by Dr. Smithson, to prescribe specific conditions that would be tailored to Mr. Shea. And I think that's reflected in some of the nature of some of the conditions as well, that there's a requirement that he provide detailed financial records. That's at JA 385. There's sort of a nonsensical combination of conditions, including a curfew, GPS monitoring, and a driving log. That's at Joint Appendix 384. There's also severe restrictions on computer and internet access when there was no evidence of sexual misconduct by Mr. Shea connected to a computer. That's at Joint Appendix 388. And so one of our concerns is that there was no individualized analysis as to Mr. Shea. And this is why we raised the McMiller case in our reply brief, that this court has previously said that standard conditions for classes of offenders are not appropriate. And we believe, even though the statutory scheme is different, that the district court's obligation to find that conditions are appropriate is similarly reviewed as its obligation in the supervised release context to make sure that they're reasonably related and do not involve a greater deprivation of liberty than is necessary. With respect, Judge Wynn, to Mr. Shea's current dangerousness, and his current serious mental illness, this court's decisions in Springer, Caporal, and in Wooden all affirm what Your Honor raised, which is that the question is, as of September 2019, was Mr. Shea sexually dangerous? Dr. Malinek said no. Currently, he does not suffer from a serious mental illness, and he's not dangerous.
Why is that date important?
That's the date of the challenge hearing, Your Honor. And so I'm just putting us in the position of the district court at the time that it made that determination. Dr. Smithson and Dr. Barnett each had to acknowledge that Mr. Shea had not engaged in any sexual misconduct. He was not collecting any photographs. He wasn't writing any stories. He wasn't making efforts to connect with past victims or with children or even with young inmates. And that's
is this evaluation during the time of his treatment? Was he incarcerated during that time period?
He has been incarcerated for about 6 years, and he was in treatment for 4.5 of those after the district courts, after he agreed to commitment. So during the entire 6 years, there was no evidence of sexual misconduct, no disciplinary infractions, no sort of behaviors that we see in some other civil commitment cases that indicate an ongoing.
So what I mean, if we're dealing with it, and I understand it, I think the law is what we're in terms of trying to understand it. I guess from my perspective, if you're dealing with a common sense application, that could give you a different result. But I just think we might be constrained by the law. I mean, we're talking about someone who's been diagnosed as a pedophile, which is described as a lifelong chronic condition. Never spending a significant time, looks like to me, in the community without something happening. I mean, if you put him back out there, it happens again. And yet, he's been there, and all of this medical, under the review of it, when we're looking at it, we're looking at this time period, and the question that comes up is, the theory is, well, has he done anything during this time period? But he's not in the community. So how do we deal with that? I mean, I understand, I guess, from the case law, it pretty much tells us that's the way we got to deal with it. That's the way I see it.
I think that's right, Your Honor. And this court confirmed in Wooden that if history were to be the only guide, then anyone who had ever been committed would never be unconditionally released. But Caporal confirms that this is a decision that's made as of the time of the hearing. And here there was no evidence of sexual preoccupation, which we do see in other cases. We see other individuals who, despite the fact that they're in prison, are engaging in behaviors that demonstrate an ongoing serious.
You say no evidence of sexual preoccupation. You mean at the time of his release, none of ongoing. There's surely evidence that he is preoccupied with sex. I mean, if you go on his history of it, but you're talking about during this period of time. What is the case that limits us to consider this in that time period? Not irrespective of history, but history not being the only factor you can go on.
There's a number of cases, Your Honor. I'd point you to Wooden in 2018. Also, this court's decision in Antone. Caporal and Springer also confirmed that the second prong, the mental illness prong, is current and forward-looking. And even if the medical literature requires a diagnosis, for example, by history, the legal inquiry is he now suffering a serious volitional impairment as a result of a serious mental illness, disease, or defect? And I don't think that there was any evidence on this record that as of the date of the hearing, Mr. Shea was suffering from that kind of impairment. So we would ask the court to reverse the district court's judgment, or at the least vacate and remand for reconsideration under the proper legal standard. We would also ask this court to give clarity to district courts in resolving these civil commitment discharge hearings.
Okay, Ms. Tarleton, wasn't there an annual forensic update that Dr. Barnett prepared?
Yes, Your Honor.
Okay, and the report said that the pedophilic disorder remained the appropriate diagnosis, right?
Yes, she did say that.
Okay. So I know he had problems some problems that weren't directly related to problems, but complying with rules, like he improperly traded some commissary items. What else did he do? He bought books from a known sex offender, although apparently not sex books, and something about dealing with a laptop outside the rules. To what extent do we consider that as evidence regarding his ability to remain outside without conditions?
I don't think that they would dictate a determination that Mr. Shea is sexually dangerous. They don't go to the very particular inquiry in these cases, which is whether he would have serious difficulty refraining from sexually violent conduct or child molestation if released. Right,
but my question is, does this show that he will push back against rules and maybe not comply with rules? I
don't think so, Your Honor. I think they are so limited. He never actually received a disciplinary infraction for any of these transgressions. They were issues that came up in treatment. And this court in Antone helpfully described the fact that someone who is in a mental health or an addiction type treatment program is not going to be perfect. And for them to be able to, have a safe space in which to make mistakes that aren't determinative is really important, and they should not be penalized in a egregious or over the top way for those transgressions, especially when Dr. Smithson acknowledged that Mr. Shea has learned from those experiences, that when he was put in a brief treatment timeout, that he responded well to that and understood that he was being held to a higher standard as someone who was in sex offender treatment. So I think his response to the repercussions that came from those transgressions is informative and indicates that, as the district judge mentioned at the end of the hearing, I take you at your word, and I found it persuasive that you would do well whether conditions were imposed or not. And I think, yes.
Can I ask you this? He was out in the community in 2013, wasn't he?
That's correct.
Has he been in custody since that time?
Since his supervision was revoked. Initially, he was serving a revocation sentence, and then he self-committed for treatment.
Yeah. And so since 2013 up until the time of the hearing, he was in custody, right?
That's correct.
So the only time that he's been in the community, most recently, they found that he did not handle things well. He had pornography. He approached this boy, paid him $100 to commit a sex act, a 16-year-old. He
So that is disputed, Your Honor.
It may be disputed, but this is what's in the psychological evaluation report, which they were relying on, and that he had a possession of pornography and half a dozen other violations of his terms of supervised release. This is in 2013. The hearing, what, 2018?
2019, Your Honor, September of 2019.
So the last time he was in the community, we have this situation where he seemed to have been doing okay in custody, but when he was out in the community, some problems arose. And so the question would naturally arise, and based on Dr. Barnett's comments, that if he's released now into the community, we can't be totally sure. And of course, these are pretty serious things. He can always, as the district judge pointed out, he can always ask for removal of the conditions or changes of conditions, but this is a heavy record he carries. He's made an enormous effort, and during the last 5 years, I think they recognize the enormous effort. That's why everybody is supporting his release. I think the only question is whether he has to still be under some conditions. And what is our standard if the district court said that I conclude that conditions need to be imposed as opposed to a release without conditions? Is that a factual finding or a legal finding?
I believe that's a legal finding, Your Honor, and this court can review for abuse of discretion. We also think that the court needs to clarify the legal standard, because I don't believe that the district court was making a finding that this is a necessary regimen of treatment or care. I'd also like to clarify that Mr. Shea was not perfect when he was incarcerated previously to this period. So this is not a case like Charbonneau, where it's someone who can be perfect and then really has a hard time.
But to go more to the point that Judge Niemeyer so compellingly lays out, I'm not in disagreement where he goes with it. The problem is that's not the standard. The standard is at the time of the hearing. And it doesn't give an exception of while you were out in the community, which I probably wouldn't disagree with if it did. And your answer really is, yeah, all that's true, but it doesn't matter because the standard's at the time of the hearing. And the testimony then must connect to say, well, at the time of the hearing, he had a mental illness. And I'm not sure, maybe the other side can tell me, at the time of the hearing, I'm not sure there's evidence of that.
I think that's exactly
somewhat sadly right, in a way to me, because it looks like to me they should be, but I just don't see it. I don't know.
And I think that conclusion is bolstered by this court's decision in Wooden in 2018, Your Honor.
All right, why don't we hear from Ms. Petrie.
Thank you, Your Honor. May it please the court, Jenna Petrie for the United States of America. There are two issues before the court in this case. The first is whether the district court committed clear error in finding that Mr. Shea failed to meet his burden of proving by the preponderance of the evidence that he was no longer sexually dangerous during the hearing.
So let me go right to the question as Judge Niemeyer sets forth, which is very, very interesting. And I think it's just, I don't know, I'm saying it's a common sense thing. I think it's undisputed. This individual is a pedophile. He was diagnosed that in the community. He is repeatedly out there doing the same thing. If I had to make a prediction on my own, I'd say he's probably going to go out there and do it again. That's just my prediction. That's not good. There's nothing medical about that. I just the feel of it. But the case law seems to say pretty convincingly that you must determine at the time of the hearing whether he suffers a serious mental illness. And absent that, you can't put conditions on him. Is that correct?
That's correct, Your Honor. And the evidence in this case.
So then the question becomes, which I know you're getting ready to go, but I want to make sure I get it. If we're there, then the question becomes, was there evidence at the time of the hearing to support what was done here?
Yes, Your Honor, there is evidence to support that Mr. Shea, at the time of the hearing, suffered from a serious mental illness, abnormality or disorder as required under the statute. And
what was that evidence? Because the other side said it wasn't. Points to the doctors who are testifying. What is that specific evidence at the time of the hearing that says he is seriously mentally ill?
Sure, Your Honor. So opposing counsel points to the testimony of Dr. Malnick to say that he was no longer suffering from a mental illness. However, both Drs. Plod and Drs. Barnett opine that Mr. Shea, at the time of the hearing, met criteria for pedophilic disorder, and Dr. Barnett additionally diagnosed him with an other paraphilic disorder not otherwise specified, which is that interest in pubescent children. And while Dr. Malnick did not diagnose at the time of the hearing, he noted that a lack of evidence in custody of someone being aroused by children does not mean that they're no longer aroused by children.
So you are saying that it's Dr. Cloud and Dr. Barnett who says at the time of the hearing, this person here is suffering from a pedophilic disorder, which they would see as a serious mental illness. They testified to this. So you don't need anything more than that, do you? If you got two doctors who say that.
There is additional evidence, Your Honors, but we do have the two doctors. And what's notable about this is that they're both using the DSM-5 diagnoses to determine that he suffers from a condition. Now, what Dr. Plod does, I think you'll see in the record, is that he opines that this doesn't quite rise to the level of a serious mental illness, abnormality, or disorder.
Excuse me, I'm sorry, I missed that one. Who did that?
That was Dr. Plod, Your Honor. However,
he said it doesn't rise to the level of a serious mental illness.
Yes. However, he noted that it is a DSM-5 diagnosis. And I'm unaware of any case where there has been any level of structure as to what rises to the level and what does not rise to the level.
Other than an expert opinion.
Other than an expert.
I mean, I don't know it, and I don't know anybody knows, but he says I don't know what he meant. What did he mean when he says it doesn't rise to the level of a serious mental illness? Which is the operative words here.
Quite frankly, Your Honor, it's entirely unclear from the testimony what exactly Dr. Plod meant when he said that. But what I'd point to here is that Dr. Plod did diagnose a current mental illness that is registered in the DSM-5, which is pedophilic disorder here. And there's plenty of evidence, both in Dr. Plod and Dr. Barnett's reports and their testimony.
And what did he base that on? Did he base that on the information that Judge Niemeyer points to, that from 2013 he's out in the community? Or did he base it on these intervening 6 or 7 years and how he is what's going on? I'm trying to understand that.
It appears that he wavered a bit, Your Honor, based on the fact that Mr. Shea has been in custody with no, as I think opposing counsel phrases, no ongoing sexual interest, but that's not correct. And what I'd point to in the records are a few places during the course of his treatment where Mr. Shea has said some pretty concerning things that indicate that while he might outwardly not be expressing an interest in children, because I think, as Your Honor noted, there are no children within his age range in the prison, but what he's doing is he's continuing to justify his behavior and continuing to use this kind of impulsive and criminal thinking that's consistent with his prior behavior. And I think that demonstrates through the course of the records that he does continue to suffer from this serious mental illness, abnormality, or disorder. Speaking specifically to some of his cognitive distortions, which are incredibly concerning in this case, we see that he refers to many of his victims as being damaged goods in order to justify why he was able to offend against him, that his belief was that he wasn't hurting them or harming them in any way because they came from broken families.
But I guess what I'm trying to understand is when you're looking at Dr. Claus, and you got Dr. Barnett too, because you say he also says he's got a disorder, so maybe there's something there, but I'm trying to understand if under the case law, you can't just look at the past, you got to look at the, in terms of, because there's a reason you're going to treatment. I mean, if you didn't, otherwise you would never get out. We could all start out and say, this is a lifelong illness. He would never get out, under that. So you got these experts, and you have the doctor says, well, I wouldn't say it rises a level to a serious mental illness because it's 2019, and maybe he doesn't know. Maybe for the reason that Judge Niemeyer has alluded to, he's not out in the community. But the law doesn't say it. That doesn't seem like to me to be the standard. It could have said, in the community. When it doesn't apply while he is in the community. It just says him as a person. Does he have this serious illness? And I don't see any direct testimony or anything even alluding to the fact that in 2019, he's in a situation where he's attracted to, let's say, prepubescent children. Not in 2019.
I think there is evidence of this in the record, Your Honor. And what I'd specifically do is
where is that? Where is that? Because I don't find that someone has said in 2019 he is attracted to these prepubescent children. I can't how to pronounce that word. I'm sorry, it's tying my tongue up.
Your Honor,
but where is that evidence? Is what I'm trying to say. I didn't find it.
Sure, Your Honor. What I'd point you to is actually not the testimony of one of the experts, but Mr. Shea himself at his Good Lives plan at Joint Appendix 135. It spans several pages, and what this is his plan for release to the community. And he himself in several places notes that he needs to stay away from young boys because of his arousal to them, to not engage with young boys because of his arousal, to not be on the internet because of his history with them. And the fact that Mr. Shea himself recognizes that he has this arousal to children, I think is evidence of his ongoing interest in children.
Well, it sounds like to me he's recognizing the history of it, and it's good that he now understands he's got to stay away because he has this history of it. But he's not saying I'm aroused to him now, so I'm not going to go around him.
Well, Dr. Barnett concludes it as a present time, says that at the present time, he has static 99R score remains at 6, which falls well above the average risk category. That he suffers a pedophile disorder, and there are currently no mitigating factors, and she lists the factors which would reduce this risk. And so it seems to me that in and of itself is sufficient to find at the present time he has a mental disorder, doesn't it?
I would agree, Your Honor. And Dr. Barnett's report, I think, points specifically not only to a diagnosis of pedophilic disorder, which is relevant in this case, but also the paraphilic disorder not otherwise specified, which is also important because as recently as 2013, we know that Mr. Shea attempted to reoffend against a 16-year-old boy, and that would fall into that paraphilic disorder not otherwise specified area. And so when we're talking
that's what
about
the whole point. That's the whole point is we're not talking about 2013. We're talking about 2019. Dr. Barnett, may have testified at that, but at trial she said she didn't consider his behavior when he was in therapy. Didn't she say that? She said that specifically. Says I didn't consider his behavior when in therapy.
Well, Your Honor, what
I mean, if you disagree, then just tell me where it is. She says otherwise. I'm just trying to understand it, but I don't see it.
Sure, Your Honor.
He definitely talking about 2013. Definitely talking about other. She's definitely talking about that, but not when he's in therapy, and that's been 6-7 years.
Actually, Your Honor, in Dr. Barnett's report, located at Joint Appendix 439 through 440. I believe she discusses his course of treatment and provides some additional information. And then on page Joint Appendix 443 through 444, she specifically points that after looking at Shea's relevant history as well as the documentation from the last year, which is the 2019 year, that part of that annual report, the diagnoses of both pedophilic disorder and paraphilic disorder remain appropriate. And the reason for that is because she has reviewed all of his information, all of that history, all that treatment information, and continues to believe that he meets criteria under prong 2 as having a mental illness, abnormality, or disorder that meets criteria under the statute.
I'm just looking at a specific statement she made. She says, I didn't really look at his time while he was incarcerated or in treatment or a program where he doesn't have access to victims. But Judge Keenan has been jumping up and down, so
That's
I think
okay.
I'm going to yield. I'm going to yield to Judge Keenan.
Okay, well, I'll try to be quick here. The record showed that he had, as indicated in the testimony at the hearing, and these are questions of mine, that he had a risk factor of 6, which was above average. What is the numerical scale there?
I believe the numerical scale ranges from -3 to approximately 12. And so he falls at a 6, which is above average in this case, and that's fairly high. And what that indicates is a static score of his offending. And so we're looking at his
did any of the doctors say that's fairly high? I think the testimony showed it was above average, but
it's above average, yes. And I don't know that the testimony specifically indicates that it's fairly high, but they all agree that it's above average. And in this case, when we look at someone who's above average, in compilation with his history of offenses and utilizing the factors enumerated in United States v. Wooden, we see someone with some very concerning risk factors. I think Dr. Malnick.
Okay, yep. I don't mean to cut you off, but thank you that you have answered that question. Let's go on to the conditions here, just in case that becomes an issue in this case. Does the record show whether these are boilerplate conditions that are applied to everybody?
They are not boilerplate conditions that are applied to everyone.
Does the record show that?
I don't believe the record specifically shows that, though Dr. Smithson, who is the treatment provider who provided treatment specifically to Mr. Shea in the commitment and treatment program, notes that she was involved in developing these. And I think she was taken out of context in some of the references by opposing counsel. She was asked whether or not she had developed any plans for other individuals, to which she said she had, just to show that she has experience in this area. But she was very involved in developing the plans for Mr. Shea, as noted at Joint Appendix page 353.
Okay. Let me not. I don't mean to keep cutting back at you, but just try to keep it, in the area that I'm concerned with. Condition number 25B essentially says that his employer should be notified of relevant risk factors. Does that mean that any employer is notified of his past?
What it means here specifically for Mr. Shea is that if he were to work for any employer, he would have to notify them of any personal risk factors of working in that position. For example,
what does that mean? Risk factors?
Well, for example,
are we talking about his psychological risk factors as a pedophile, that he would have to go to an employer and say, let's just say he's working in the back room in a nursery, putting flowers together, never comes in contact with any children. And does that mean he has to tell the head of the nursery that he's a pedophile?
What I think he needs to do, based on that provision, is that he needs to acknowledge that he could, in that position, come in contact with children and make the reasonable people, whether it's his employer or the employer of the nursery.
Let's just assume that the record would show, as a hypothetical, that he would have a job where he couldn't come in touch with children, just couldn't. Does the employer then, under that condition, have to be notified that he's a pedophile?
No, Your Honor. This is the risk specific from his condition translated into the position. So if there's no risks that would translate into the job, meaning that he's not going to come into contact with any children, he's not going to be crossing state lines, he's not going to be working at a school or close by a school or a park, then there's no need under this specific condition.
Okay, thank you.
And what I'd also add, in reference to Your Honor's question about the boilerplate conditions, I believe opposing counsel referenced several other cases where there are similar conditions. However, what I'd like to note is that both United States versus Simpson and United States versus Williams, the cases referenced, they actually had conditional release plans that came after Mr. Shea. And what I offer that to show that Mr. Shea's conditions were very specific to Mr. Shea. And if we were to walk through each of the conditions, and some of the conditions that were noted by counsel, such as keeping a driving log, and some of the other things are specific to Mr. Shea, and they're specific to him for reasons. For example, the driving log is because he has a history of driving around and picking up children to use them as allegedly as laborers, but then sexually offending against them. So every single one of these conditions is very specific to Mr. Shea's treatment plan.
What about the rationale of McMiller? The conditions are reasonable, generally. And if they're unreasonable, the court has ways of dealing with it when they're properly objected to. But what about the rationale of McMiller that, if you're going to restrict somebody's life so much, and for good reason, you need to tell them why you're doing this. Exactly what the court said in McMiller. Why isn't that something that should also apply here? Not trying to divest the court of any authority, but just simply, like when you're putting somebody on probation, a judge tells the defendant what could happen. You're informing them to help modify their behavior. Well, isn't that the same sort of thing that pertains here? That the court needs to give some sort of explanation?
I don't think that the court needs to give an explanation here for a few reasons. And first and foremost, because it's not required by statute. So what 4248E requires the court do is find whether the conditions proposed by the director of the facility are adequate and appropriate. And I think the specific word used by the statute is appropriate. And so what the court did here is find that those conditions were appropriate. I note that some of the sentencing issues, like in 3553 and 3583, though that section specifically requires the court to give reasons why it's imposing the conditions. But we don't see that same language here. So I think that that's an important difference. What I'd also note is while the court didn't specifically explain the reason for every single condition in this case, if we look to the court's adoption of the government's findings of fact and conclusions of law, as well as the statements made by the court at the close of the hearing, we do see a lot of rationale for the imposition of the conditions as a whole. And what the court talks about is that Mr. Shea doesn't have a good track record in the community. He's had three.
Yeah, excuse me, thank you. So if, let's just say his counsel had objected to the conditions, what would be your position then? In other words, said, we agreed that all of these make sense, except 25 just doesn't make sense, that you have to go contact his employer. Would the court then be obligated to address it?
I think then if there was a specific objection, the court would probably like to hear from the parties as to the rationale behind it, why it was imposed, and how it relates to the regimen of medical, psychiatric, and psychological care. And that could have been offered specifically here. But I think, as Your Honors noted during the first argument, that wasn't the case here. Neither before the hearing, when the conditions of release were proposed by the government, nor during the hearing, nor after the hearing, did Mr. Shea or his counsel object to the imposition of these specific conditions. And in fact, what Mr. Shea did was ask the court to add another condition. And what his condition is very specific. What he asked the court to include is that he not view adult pornography, which shows that Mr. Shea was incredibly familiar with the conditions, that he had reviewed them to know that that wasn't initially included. And so he was aware of all the other conditions that were included in his release and didn't object to any of them, didn't take that opportunity to ask the court to dial them back or to change them or to change the language. He asked the court to add another one. And the government believes that this shows that he did consent to these conditions, and to now raise this issue on appeal, I would offer is inappropriate. Your Honor, I see that my time has run, so I'd like to briefly take a moment to conclude and ask that this court find that the district court did not commit clear error in finding that Mr. Shea failed to meet his burden by a preponderance of the evidence that he is no longer sexually dangerous and suitable for release without conditions, and also find that the district court did not abuse its discretion in imposing on Mr. Shea a regimen of medical, psychiatric, and psychological care or treatment as outlined in 18 U.S.C. 4248E. Thank you, Your Honors.
Thank you, Ms. Petrie. Mrs. Tarleton, you have some rebuttal. Can you turn your mic on? It's muted. Can you test it?
Thank you, Your Honor. My apologies.
Yep, that's fine. That's fine.
I'd like to cite the court to United States against Caporal, footnote 4 on page 138. And that's where this court confirms that a diagnosis is only the starting point for the court to consider the true thrust of the 4247A6 inquiry, whether on a case-by-case basis, the respondent's underlying condition constitutes a serious functional impairment. And so that's how you could have someone who might apply the medical diagnosis of pedophilia, hebephilia, or another mental disorder, but not find that it rises to the level of a serious mental illness as required by the statute. That's United States against Caporal. Dr. Malinek said that he does not meet the criteria under prong 2. That's a JA 249, 250. Dr. Plod said no at JA 283 to 286. And Dr. Smithson and Barnett acknowledged that there was no sexual misconduct or behavior of that type while he was in prison. That's at JA 346 and JA 351. And at JA 351, I think Dr. Barnett sort of complicates her diagnosis, her current diagnosis of pedophilic disorder when she says, you know, Mr. Shea has reported being a very sexually preoccupied individual, but there wasn't really any evidence of that at all. There was no indication he was having sex with other inmates or engaging in sexual conversations. There wasn't an indication of sexual preoccupation there. So I think that that definitely decreased or improved with treatment. I also wanted to address, Judge Keenan, your question about the static 99. Dr. Malinek and Dr. Plod both talk about this in their testimony and in their reports. But as the name indicates, that's a static indicator, and its number does not change over time. And so once someone is a 6, they will be a 6, always and forever. And so that's not really a good indicator standing alone of a person's current serious mental illness or of their sexual, their serious difficulty refraining from sexually violent conduct or child molestation in the future.
Let me understand what you just said. You're saying that when Dr. Barnett testified he's a 6, she could have testified about that in 2013, and the same thing would be 2025, because that's a static. But now, does it go up or down? I know the word static has its meaning, but how do you get it to go up or down?
That's right, Your Honor. It is static and it stays the same. There are some age-related indicators that can cause it over long periods to decline a little bit, but that's why the doctors...
You're telling me this thing is like IQ?
It's fixed. I won't get into, I don't know the science of IQ well enough to agree to that statement, but I will say that...
But I think it's important. I think it's important because if we're relying on her, she said it was a 6, and we're making a big deal that, well, that's above average, he won't ever get over that.
That's right.
I mean, is that
That's
in the
exactly
record?
right.
What you're saying, what you're telling me is in the record right now?
Dr. Malinek and Dr. Plod both address it in their reports and in their testimony. And I will say that's why there's always questioning about dynamic risk factors on top of the static score. And that's where Dr. Malinek and Dr. Plod get into the protective factors. So I'm looking specifically at Dr. Plod at JA 288. He goes through the major protective factors. The first is his age, that he was 64 at the time of hearing, and that there's an age cohort associated with almost no reoffending. Number 2, he talks about how Mr. Shea self-committed, and he talks about how that's a rare phenomenon, and that in the last 4.5 years he's done treatment. That's a significant period of time. He's not been terminated from treatment. He's advanced to phase 4. He details all of this. And he also talks about his family support and his financial resources, which are 2 protective factors that most detainees in Mr. Shea's position do not enjoy. And those are in the record at JA 290. They also talk about the fact that he's not a disciplinary issue. This is, again, Dr. Plod. He said, I think the biggest thing is something about coffee and Dr. Pepper, which I don't see as really relevant to a sexual risk evaluation. So I think it's important for this court not just to take these static indicators or historical markers in isolation, but rather to look at its decision in Wooden at 607. We quoted this at page 24 of our opening brief. To accept the government's argument would effectively mean that an offender diagnosed with pedophilic disorder could never be released, as the government could always prove future impulse control problems by pointing to past failures to exercise control. And that cannot be true because the Adam Walsh Act provides an avenue of unconditional release for the appropriate detainees. And we believe that Mr. Shea is exactly one of those people. So again, we would ask the district court, ask this court to reverse the district court's judgment and order that Mr. Shea be unconditionally released.
All right, thank you. We appreciate your arguments. Our custom and practice, as you know, is to come down and shake your hands, greeting on behalf of the court. It's unique in this country, but the Fourth Circuit's very proud of that. We can't do that today, but we still want to greet you and thank you for your arguments. And with that, we'll proceed on to the next case.
Thank you, Your Honor.
Thank you. All right, do we have Ms. Leiston? Are you?
Yes, Your Honor.
And Ms. Fritz? Can you hear us?
Yes, Your Honor.
All right, why don't we proceed with the case of United States versus Goins, and Ms. Leiston, we'll hear from you.
Thank you, Your Honor. May it please the court, Jenny Leiston for Christopher Goins. Your Honors, the district court erred here in denying Mr. Goins' 2255 Johnson petition. This court held in United States versus Hodge that the government must identify all convictions it wishes to use to support a defendant's ACCA sentence enhancement at the time of sentencing. The government cannot identify only some ACCA qualifying convictions at sentencing, thereby limiting the defendant's notice of which convictions to contest, and only later raise additional convictions to sustain an ACCA enhancement once the burden of proof has shifted to the defendant. Your Honors, the district...
Is that, let me ask you, you started out with that argument. What were the issues we certified for appeal?
Honors, the issues certified on appeal were whether Mr. Goins' breaking and entering conviction and the assault conviction, which is the...
We only certified 2 questions, right?
Yes, Your Honor, but we contend that the certificate of appealability encompasses this Hodge argument.
All right, why don't we address the 2 questions? One is whether North Carolina breaking and entering is a violent felony, and 2, whether assault with a deadly weapon with intent to kill, inflicting a serious injury, is a violent felony.
And Your Honors, I realize, of course, that those are sort of phrased in the abstract, but of course they don't exist in a vacuum. They exist in this case.
I understand, but those were the questions we certified.
Yes. So, but a part of that necessarily was, did the district court err in determining that this was a violent...
We didn't ask that question. We didn't ask whether the court erred. We asked whether those were violent felonies. And of course, Townsend answered the second one already, hasn't it?
It did, Your Honor.
So we're left really with the decision whether breaking and entering on appeal, that's what we certified. I mean, we're here on a 2254 pursuant to a certificate of appealability.
And so, Your Honors, we contend, however, that under this court's case law, that when this court issues a certificate of appealability and certifies certain issues, this court's case law seems to indicate there is a decent amount of latitude built in there as to the arguments that a litigant may make on appeal under those issues. And we contend that basically the district court erred in saying that the breaking and entering conviction was a violent felony and that the assault conviction was a violent felony when the PSR never designated those convictions as violent felonies, as legitimate ACCA predicates. And I would point to this court's decision in Winbush, and I would remind the court that the COA, the issue certified in Winbush, was whether the district court erred by rejecting Winbush's claim of ineffective assistance of counsel upon the finding that Winbush's Ohio robbery conviction constitutes a crime of violence.
The difficulty with that analogy is that we asked in that case whether the district court erred in doing something. In this case, we asked 2 abstract questions, whether particular crimes are crimes of violence. Now, we can handle what to do if we conclude that they are or they are not. But I don't see how you get around the simple question, is A crime of violence, is B a crime of violence?
So, Your Honors, I do believe that this is built into the issue that has been certified on appeal. If it is not, Your Honors, then that is my mistake completely. I have to say that this was something that I thought about. I took this appeal over for a colleague, and when I saw that it had a Hodge issue, my first thought was, do we need to expand the certificate of appealability? And
well, there's a way to do that. There's a way to do that.
There is.
But our local rule says that if you don't do it, we're not allowed to consider anything in the brief that refers to it.
So again,
22, local rule 22. You're familiar with that, aren't you?
Yes, Your Honor. But then when I looked at Winbush, I thought I think we're fine here. And not for nothing, but I have to say I consulted with more experienced appellate colleagues, and everyone was on board. Everyone agreed that we didn't need to expand.
Tell us more about Winbush, because I'm not in disagreement on that to some extent. I mean, Winbush is pretty expansive. I don't think it's as limited as it appears. Yeah. I mean, when you look at Winbush and the issue that was presented, and ultimately what this court then considered, the issue was ineffective assistance of counsel. How in the world it then gets into a Hodge situation is just baffling here, but they did. And that doesn't look too limited to me. It was an ineffective assistance of counsel. Let me go back to Winbush, make sure I got it right. He gave two issues, says it was not a career sentence and that it was an ineffective assistance counsel. And then the court got in a Hodge issue.
Yes, sir.
And it resolved it. I think anybody reading that would say that the same thing exists here. It looks pretty clear to me.
And I would just also add, Your Honor, that
I think without it you'd have some problems, but Winbush is on fours with this situation. There's nowhere in the world you can get to that issue if you don't do something and expand it. And the other thing is, I suppose, expanding an issue of this court has the authority to expand it. Of course, the limitation is, well, could we do it now? I mean, could we do it now? And then if you want to, we'll order a supplemental briefing on it. Because we're dealing with fairness here. And ultimately, I'm not so convinced we could not right now certify this or to expand. And if you felt like, well, must we do it for a briefing? We'll just say, have some more briefing on it. But you don't need briefing on it because everybody's briefed it. So ultimately, when we're dealing with cases like this, this court and the courts go out of its way when we have defendants in situations like this. We get in other situations that you find all kinds of reasons to look beyond the evidence and get to it. But this is our point. You got Winbush. And I don't see how you get around Winbush.
I agree completely, Judge Wynn. I would also say that this court does have the authority to expand the certificate of appealability. And I do think if there's any question that the certificate of appealability as issued does not cover this, I think it would be appropriate to expand, especially given how low the standard is for issuing a certificate of appealability. It's just is this an issue on which reasonable jurists could debate? And I think this issue absolutely presents a strong meritorious issue. And so believe we would stand on Winbush, Your Honor. So, Your Honors, we believe that the court did err under Hodge in relying on these previously non-designated ACCA convictions to sustain Mr. Gowen's ACCA status. The court found that, now of course the court found that the PSR's designation of the predicates was a typo. However, we believe that is both factually dubious and legally immaterial.
How many typos is it supposed to have made? I mean, was it one or what? It looked like it was more than a typo. It must have had, I don't know. Tell me about the typo. What were the actual numbers and what does it contend?
Yes. So, Your Honor.
Because he said no one testified it was a typo. It makes the determination on your own. It was a typo.
Yes, the district court came up with this completely on their own. The PSR says that the ACCA designated the ACCA predicates as paragraphs 9, 14, 16, and 17. the district court said, well, those are categorically excluded, and so those must be a typo, and so I'm going to say it's paragraphs 10, 15, 17, and 18. But there's no contemporaneous evidence in the record, Your Honor, to support that designation.
What about the government's allusion to the during sentencing? The court didn't refer to stolen property crime. The court referred to the crimes. In other words, the explanation the court gave is there was a paragraph inserted that knocked off the numbering so that the actual numbers are really 10, 15, 17, and 18. But those crimes were alluded to by the U.S. attorney during the sentencing.
Absolutely, Your Honor.
And everybody assumed that that was correct. Nobody took objection.
So nobody objected. I do think that's interesting. So I'll say two things. One is, you're right, on JA 34 at the original sentencing, the government argues he has 4 felonies that count for the armed career criminal. Each of those is extremely violent in terms of the criminal conduct. Well, Your Honors, then how could paragraph 10, the breaking and entering conviction in which he broke into a carburetor shop and stole a few items when he was 16, that's not an extremely violent, that's not a violent criminal conduct. So I would also point out that the government on direct appeal to this court and Mr. Gowen's appeal to this court on direct review specifically told this court that the felony possession of cocaine conviction at paragraph 9 was one of the ACCA predicates that it was relying on. And so I think that's pretty strong evidence that at least paragraph 9 wasn't a typo, because the government...
But what you're really saying is we ought to have the government make them try the case. I mean, you're going to put somebody in jail for years and years. You don't come back later on and says, no, you don't say it. The judge says it. You don't never say it. There's a typo. And then you go in and, go and look at the argument and dance it around and come up and says, okay, this is what this means. It's not a hard thing to do. If you're going to put someone, it's only 3 offenses that you need. Just tell them what the 3 are. Not put down a bunch of numbers and then come back and say, well, there's a bunch of typos in here. It didn't mean this. It meant these other ones here. When Hodge tell you you can't look at the others, but now you have, instead of, because you got Hodge, if you didn't have Hodge, you could have just said, oh no, we'll look at these other ones here. But you can't do that. So now you say, oh, this must have been typos. There's got to be these others. I mean, you could do it in every case. You probably could do it in every case that I can think of. that would have additional factors in there. Now, I guess nowadays, why wouldn't you include the rest of them? I mean, I don't understand why the government, when they're doing it, why would you not just give them all? I would think you would. It wouldn't make it. I don't see any prohibition for doing so. Why would you just limit yourself?
And so, Your Honor, I agree completely. I do think that at best there is a mass amount of confusion here over which of these convictions qualified as ACCA predicates at the time. And this is the important thing about Hodge. It says you have to have the notice at or before sentencing. So it doesn't matter at the time of collateral review. It matters at sentencing. And I think there is a lot of confusion, and that there is no evidence in the record to show that Mr. Goins had the notice that Hodge says that he needed at the time as to which ACCA predicates were going to sustain that ACCA status. And especially in this, you can't come back on collateral review and say, oh no, it was a typo, no biggie, and redesignate additional convictions. And so, Your Honor, now I would say that, Judge Niemeyer, I know that you wrote United States versus Rumley. I do think that perhaps the best thing to do here is to just send it back to the district court for reconsideration in light of Hodge, in light of Rumley. The district court can then make the decision whether it wants to order a whole new pre-sentence report, have a whole new de novo resentencing. And I will just point out that just because and we'll see. Give Mr. Goins his opportunity. Give him his notice. Give him his due process. And if he remains ACCA at the resentencing, that doesn't necessarily mean he's going to get the same sentence, because of course the court in this case gave a 5-year upward departure from the bottom of the ACCA sentencing range. And so I think at a resentencing, the district court could very well think that, well, in light of the fact under Johnson, he has far fewer ACCA predicates now, in light of the rehabilitation evidence of the last 10 years.
Why would we send it back? Why wouldn't we just order resentencing? I mean, it seems to me if you're right about this, that there wasn't an error, I think that's actually a close call whether there was an error or not, because it's not as confusing as it sounds. It's just one paragraph number offset. And if the pre-sentence order between its original draft and the final inserted a paragraph, it would throw all the paragraphs off by one. And the district court thought that's what was going on, because at sentencing they didn't refer to the stolen property, nor did they refer to the drug. They referred to the others. And so the court assumed that offset in numbers was just an error. But if it wasn't an error, I guess your suggestion is we could have the district court determine whether it is, or if you don't think it was an error, why don't you just request a resentencing?
And so that would be our first request, Your Honors, is just to have a resentencing, because I don't think under Hodge that he qualifies. He doesn't have the 3 necessary predicates under ACCA that were designated at the time. But I would also—
Well, Hodge holds that we can't jumble around the predicates on collateral review, because it didn't give your client notice and opportunity to defend, and it changes the burden of proof and all that stuff.
And I would just point out, Your Honor, so you noted that maybe the numbering was off by 1, and I would just remind the court that, I know it doesn't appear in the record, but I can assure the court that the draft PSR is absolutely identical to the final PSR, and I would be happy to submit that. And if the court, I believe, had just looked at the original draft PSR, the court would have seen that there wasn't any off by 1 sort of renumbering going on there. But I believe, Your Honors, that this court should send it back to the district court because of the Hodge error, Your Honors. And if there are no other questions, I will save the rest of my time for rebuttal.
All right, thank you. Ms. Fritz?
Good afternoon. May it please the court. Christine Fritz on behalf of the United States, and we're asking you to affirm the judgment of the district court. Here, I'd like to begin with the certificate of appealability, because I think that is an important issue, because this court certified essentially 2 questions of law: whether assault with a deadly weapon with intent to kill, inflicting serious injury, is a violent felony, and whether the same can be said of breaking and entering. And the case law is absolutely clear now. All of those qualify. And for example, breaking and entering has qualified since 1992. So I think it was pretty clear to everybody at the time of this sentencing what convictions were being looked at. Now, what's interesting is that defense counsel on appeal had asked to expand the certificate of appealability to reach breaking and entering, which quite frankly is confusing to me, because the defendant couldn't have raised a freestanding 2255 challenge to breaking and entering in the district court to begin with. There wasn't any intervening Supreme Court law that would trigger the 1-year statute of limitations that would have allowed them to bring that up. So, and effectively, that's what the district court said when it indicated that breaking and entering is an ACCA predicate. There's no dispute about that, and you can't challenge that under Johnson. And then the district court proceeded to address the 2 assaults with intent to kill. So we have a 2255 that initially challenged all 3 of the assaults. Then we have an expansion of a certificate of appealability at the defendant's requests for breaking and entering. And now, after Hodge is issued, we have a Hodge claim saying that it was unknown at the time of the sentencing which were the ACCA predicates. And I would submit to the court that that doesn't hold true on this record, that the concerns that were animating this court's opinion in Hodge are not present here. We have a defendant who had a breaking and entering, which has been a crime of, or has been a violent felony since the 90s. And he had 2 assaults with intent to kill, and he had another assault with intent to kill. The PSR, or I'm sorry, a third assault that did not have the intent to kill. The PSR made it clear that there were 4 violent felonies that were being relied upon, which that in and of itself distinguishes it from Goins because distinguishes it from Hodge, because in Hodge, this court emphasized in its opinion that there were 3 and only 3 ACCA predicates. So here there were 4, and now we know that in light of Johnson, one of them doesn't count. So now we're down to 3. But I think that the district court didn't have any difficulty saying that this was a typographical error because all the paragraph designations were off by 1. Essentially, if you put another rung in a ladder, everything was one rung higher. And it was so obvious to the court that this was a typographical error. And a court can take, under Rule 36, a court can correct an error that it sees after giving appropriate notice to a party. And I'll point out that there was an interim opinion in this case where the breaking and entering was relied upon, and the footnote indicating this as a typo, the court was attentive, brought this to everyone's attention, and there was no issue raised whatsoever regarding the breaking and entering or regarding notice or opportunity to be heard. And I'll note that the defendant did file an objection to that interim opinion in an abundance of caution to protect appellate rights, specifically to the finding that assault with intent to kill is an ACCA predicate. So, and I'll also point out the nature of the felonies, which is what also made it easy for the court to realize that at some point in the drafting process, whether it was when the probation officer was drafting his own first rounds of the draft, whether it was the draft that was sent out to the parties, I did attempt to get a copy of that. I was unable to locate one. But effectively, a paragraph got added prior to the criminal history, because otherwise there would have been simple possession of cocaine, possession of stolen goods, a misdemeanor assault being relied upon as ACCA predicates. It was so obvious to the district court that that wasn't the case, that she wasn't going to rely on that she noted that and fixed it. And I will point out, going into this sentencing, there was no dispute, the original sentencing, there was no dispute that Mr. Goins was ACCA. He had shot somebody in the stomach, he gutted somebody with a survival knife, he attempted to slice a woman's throat, and then he broke and entered into a structure. He is the type of defendant for whom ACCA was created. And he's not like Hodge. Because our position is that those were the ACCA predicates all along. Breaking and entering, assault with a deadly weapon inflicting serious injury, assault with a deadly weapon with intent to kill inflicting serious injury. So this isn't a substitution or a replacement case.
Okay, Ms. Fritz, you're saying that these were the ACCA predicates all along, but were these the ACCA predicates designated for consideration in the pre-sentence report?
These were not the paragraphs that are referenced in the pre-sentence report.
So why don't we just want to do it right? That's what I don't understand. We're reading into what the district court thought about this typographical error, but we're talking about somebody who is going to be put away for a long time, and deservedly so. But why shouldn't the system operate properly so that it's clear that this was done carefully and with integrity? What's the loss to the government on that?
Our position is that they were ACCA all along, and I think what's complicated in this particular case is that this notice issue came out of nowhere on appeal after Hodge was decided. That makes it different than Hodge. Hodge had 3 convictions designated, and then another one was pulled in. And immediately, defense counsel said, I object. And actually, in Hodge, the government initially conceded. So the defense counsel for Hodge immediately said, I object. I need time. This wasn't relied upon before. I want to research the legal issue of estoppel and waiver and all these other things. And then that same attorney filed a supplemental response emphatically contending that it should not be permitted that this other conviction be relied upon. And also, in that particular case, in Hodge, there were concerns about whether the conviction was in fact a qualifying predicate, because that conviction dealt with a controlled substance offense. And defense counsel in Hodge represented that as of the time his response was due, he had not been able to determine definitively the maximum sentence to which Hodge could have been exposed.
Right, but it sounds like your argument is, since we all know under Rumley what's going to happen, let's just call it a day. Isn't that what you're essentially saying? Rather than to procedurally go through the hoops and give him the sentence that he deserves.
My response to that is that the government also thinks that procedure is important. Here, the certificate of appealability doesn't extend to that. Notice was never, ever presented as an issue to the district court. So if we're going to expand
is there any reason the court can expand it now? Could we do this now? I mean, it seems like we conferred this jurisdiction on ourselves. I know at the time of the briefing, and if the briefing is important, we just say, give us some supplemental briefs on it. Can that be done? Is there any prohibition? My question is there any prohibition on this court now from expanding the appeal of the certificate?
I don't believe there is. I think it is a separate inquiry, and that did not happen here. But if the court were to expand the certificate of appealability...
Well, I know things didn't happen, but the whole business of those typographical things didn't happen either. The court came up with that. We're doing the same thing the district court did on it that you argued you can do. This is just a simple question, and it's really not going, as Judge Keenan has alluded to, it's really not saying, you're doing something so special, you're just being fair. And that seems to be somewhat important in these procedures. I would think so. You just want to do the fair thing. We're not saying you should go free or should be in jail. That's a procedure. Let's follow the procedure. And if now it's here's another procedure. Didn't expand the appealability for the certificate. Well, we can, so we'll do it. I mean, if we do that, and I'm not sure any judge couldn't do it. I mean, I don't know if you need a whole panel. I mean, that was maybe before the panel you do need it, but it seems like to me we could expand it. So if you get beyond the appealability aspect in terms of certificate, then you get into the merits of it, which is where I understand a great deal of your argument has been, which would tell me you would need a supplemental briefing if you did expand it, because you pretty much have argued it from that perspective.
I think, again, focusing on the procedure, since this was an issue that was never raised to the district court, it would have to be subject to plain error review. And that is important.
What issue are you talking about? What are you talking about? The issue of the expanded certificate of appealability?
Whether a Hodge argument. Defendant's Hodge argument, which has been minted.
Oh, the judge knew that was there. The judge had to know that was there, because if you didn't do that, you would have never gone into the typographical stuff. You just said, we're going to look at these other issues here, other convictions. You had to know that was there, because I'm going to give a judge a lot of credit on that. That judge knew that Hodge was a problem in this case if you didn't find some reason to say, hey, we can do it. Don't you? I mean, you think the judge didn't know about this Hodge thing and did this?
I absolutely think the judge didn't know about Hodge, because Hodge wasn't decided until this case was on appeal on a certificate of appealability that was limited to assault with intent to kill. So no, I don't think it's appropriate to say that necessarily the judge was thinking about Hodge. I think the judge was going through and carefully looking at the ACCA predicates, and it realized, oh, wow, these were off by one, because I obviously was relying on the 2 assaults where he attempted to kill somebody as ACCA predicates, as well as the breaking and entering, which has qualified. So I think that a Hodge type argument, either, I mean, I suppose it was raised by the district court and defendant didn't have any problem with it, so maybe we have some sort of waiver, or it was never raised because everybody knew what the ACCA predicates were. And so now the defendant has the obligation to demonstrate plain error on review. And Judge Keenan,
is this something we're going to see happen? Is this going to be happening over and over again? We're going to be having to deal with this, or you think this is a one-shot deal on this case? What happened here? You think this kind of case is coming up again?
I think that this is the one-shot case. I truly believe that a paragraph was added by the probation officer during the drafting process. I think so too. I think it's just a matter of, why don't we just have this judge in this one case do it right like everybody else, be done with it. I mean, it's not like what we do is going to change the flow of life forever. I just tell you, in fact, it'd be pretty instructive. This is how you do things, and it probably would make, you didn't try the case, I'm sure you might have, I don't know, but whoever tried the case, a little bit more careful how you do these things. Seems to me it's simple. You know, you got 3 predicate offenses. Why don't you just list them right there in front of them? Or if you got more, I don't know if there's any prohibition of putting more than what's up there than you need. Because we've said that. You've listed 4 or 5. Well, and then we'll say, well, those 2 weren't any good. So, well, you still got 3. I've seen that. I will say
it didn't matter if you had that other stuff up there. You had those 3. That was it. Now, you could put up there that he was out barking at the dog one night and over frightened the dog. And that's not an offense, but this is what it doesn't matter because you got 3 others. So I guess I don't understand why, when you're faced with a case like this, as serious as this, with a man with a record as extensive as this, why wouldn't you put it all in there?
Our position is that it was a typographical error that was overlooked by the parties, by the district court, by this court on direct appeal. And when the district court judge was caused to look at the specific offenses again, she realized that typographical error.
By this court on direct appeal, we didn't overlook. We don't make that determination.
I will say one of the primary arguments advanced on direct appeal was that the ACCA designation sentence was sufficient, such that any kind of upward departure above and beyond that was inappropriate. So I think that it's fair to say that throughout the life of this case, until Hodge came down, everybody knew what the predicates were. And I'll also say, Judge Wynn, in response to, at the time, there wasn't a requirement that these be listed. And I'll point out that now in our circuit, I believe the practice is to not just list the paragraph number, but to also list the name of the offense and the case number, which, had that been the practice back then, I think this whole thing would have been avoided. It probably would have had the incorrect paragraphs, but the correct crimes and case numbers. And ultimately, it is the defendant's obligation to persuade this court that there was an error, that the error was clear, that it affected his substantial rights, and persuade this court that you should recognize it. And Judge Keenan, you had mentioned that it's likely that the same thing is going to happen. And we believe that, yes, he remains.
No, I was suggesting that was implicit in your argument for us to take no action here, because it was your view that nothing different would happen.
Okay. All right. And I think, though, that the defendant has to persuade you that there would be a different result. That had this Hodge error not happened, and I don't think it's a Hodge error, I think it's a typo, and it was properly characterized by the court as such. But had this not happened, the result would be different. And I do believe that Rumley comes into play, because critical to what I understand the defendant's argument to be is that you are frozen in time and you can never, ever look at the whole realm of a defendant's criminal history. And Rumley refutes that notion. And again,
if I understand fairly, I think the defendant's argument is that he wants a resentencing. That's what they want, and they'll take their shot as to whether they can improve their situation on resentencing. But I'm not sure what you're saying is their argument. I don't think they say everything's frozen in time. I think they want a bigger procedure than a collateral procedure to address this. They want a full resentencing, if I understand correctly.
My understanding of the reply was the idea that having failed to designate those convictions at the original sentencing, or having the numbers off by one digit, it would never be possible to rely on those convictions for an ACCA status. And I think that Rumley makes clear that, yes, if there's a resentencing, it obviates the notice and opportunity to object concerns. It also obviates concerns about who bears the burden and the scope of appellate review. Yes, Judge Keenan.
Okay, Ms. Fritz, I'm struggling here with whether your brief really relied on the local review of plain error. It looks like you referenced Hodge in a footnote and mentioned plain error, but then you conducted de novo review throughout your brief in your analysis. So don't we have to go on de novo rather than plain error, because you seem to not rely on it? I mean, you noted it in that footnote, but that's not your analysis and not your discussion in your brief.
The first step of the plain error review is necessarily whether or not an error occurred. So I tend to think that in some ways is what I was discussing what happened in terms of arguing that there wasn't actually an error here because he wasn't lacking notice. Our lead argument was, of course, that this is not what the court certified. But if the court were to look at this, it would have to be under a plain error standard of review.
Okay, do you raise the plain error standard of review in the body of your brief other than the reference to that one footnote?
You
can help me with that, because I honestly don't remember offhand.
I raise it in the standard of review section. I say that normally it would be de novo for law, clear error for findings of fact. When it's not raised below, review is generally constrained to plain error. However, it's
Did you make this specific argument in the body of the plain error case? As I said, I don't recall seeing it, but that doesn't mean it isn't so. So
I think we primarily focused on there not having been error, which is the first prong of the plain error analysis.
Okay, thank you.
So for all of these reasons, we believe that Mr. Goins' ACCA designation at all times did in fact rest on convictions that were undisputedly ACCA predicates at the time of his offense, as opposed to something like a misdemeanor assault or possession of stolen property. And that under the circumstances of the case, everybody knew that. Alternatively, if this court chooses to reach the Hodge issue and find that the defendant has sustained his burden, we would agree that the appropriate remedy would be a full resentencing, at which time the typographical error can be corrected in the PSR and this can be addressed there.
All right, thank you. Ms. Lyston, I think you have some rebuttal.
Thank you.
Can I ask you, just as a preliminary matter, the last question that was involved in the dialogue with Judge Keenan, what is your view about the standard of review in this on the Hodge issue?
So, Your Honor, we have, of course, contended in our reply brief that plain error does not apply under Winbush. And so we contend that we're not under the plain error standard of review, which, of course, the government did not make an argument in this brief about plain error. But we contend, of course, that even if plain error applied, that Mr. Goins satisfies all the plain error standard, the steps in plain error. It's definitely error. It's plain under Hodge. It did affect his substantial rights. And we believe that you should notice the error. And Judge Keenan, I would say when you were asking about just notice and fairness, I would point you to this court's, the words in Hodge when it, In Hodge, this court was quoting the Supreme Court and stating that the public legitimacy of our justice system relies on procedures that are neutral, accurate, consistent, trustworthy, fair. And so I don't think there's any reason to treat Mr. Goins any differently from other defendants who have gotten relief under Hodge. And I would point, actually, there's a wonderful.
Well, the question, I know, but the question that I'm raising is clearly the district court didn't address Hodge. As a matter of fact, Hodge wasn't even decided then. And before Hodge, there was no prohibition for looking at the pre-sentence report and finding that there were 3 ACCA offenses. So Hodge introduced the notion that the government has to designate which ones, especially when disqualification of one would result in a non-ACCA enhancement. But this was not raised below, and it's now presented for the first time above, and the district court didn't get a chance to address it. I do note that the government did state in its text, where such argument is presented for the first time on appeal, plain error analysis applies. Now, if plain error analysis applies, then we do have some additional questions as to would it make a difference?
And it would make a difference, Your Honor. And I would say that I would point this court, I think it's a great example of how it does make a difference. United States versus Nipper, which I cited in my reply brief. That actually was, in that case, the defendant was granted relief under Hodge and went back for the resentencing. And under Rumley, the district court did granted a de novo resentencing, got the new pre-sentence report at which Mr. Nipper had adequate notice and due process and all that. The court decided that he did still have ACCA status, but it nonetheless gave him a lower sentence on remand at the resentencing. And we think that the same could absolutely happen here, that the district court could determine that now after Johnson, he has a far fewer ACCA predicates, and that and also it could consider evidence of rehabilitation under Pepper. And so, Your Honors, and I would also just point out that everything that you just said about how no Hodge notice was raised below in the district court, the same happened in Winbush, and yet Winbush said still that that the review was de novo. So we don't contend that we're under plain error. However, we feel that even if we are under plain error, that Mr. Goins does satisfy that plain error review.
Okay. Thank you very much.
Thank you.
We would normally come down and greet counsel. As you know, that's the practice in the Fourth Circuit. We cherish it and would love to shake your hands, but please accept our greetings and thank you for your arguments. We'll take a short recess, 5 minutes.
Thank you.
Court will take brief recess.
open court again.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, we'll proceed with the United States versus Rafikian, and Mr. Grano, we'll hear from you first.
Thank you, Your Honor. Good afternoon, and may it please the court. Agent Taft Grano on behalf of the United States. Obviously, there are a number of issues in this case, more than can be covered at oral argument. So I thought I would start with some that the government views as most central to the case. First, the standard for a Section 951 violation that we believe the district court improperly heightened by adding elements, both with respect to its references to civil agency law and with respect to treating the legal commercial transaction as an element as opposed to an affirmative defense. After that, if time permitting, I'd like to address some of the evidence in the case, as well as our view that the district court's new trial orders were legally erroneous in some cases because of procedure and in some cases for failure to apply the governing standards. Turning first to the standard for a Section 951, the Supreme Court has been extremely clear that courts are not permitted to add elements to the plain language of a congressional statute. And that's precisely what the district court did here, both by referencing an inopposite area of civil agency law and by disregarding canons of statutory interpretation that would provide that an exclusion from a definitional provision is an affirmative defense of a statute and not an element.
Well, even if you're right, and the court imposed on you an additional burden, an additional element to prove, and defined agency narrowly, the jury still went your way. So
yes,
doesn't that obviate some of that?
It does, Your Honor. Actually, the district court did not instruct the jury specifically on civil law agency. This was something that came up after the jury had been instructed after Rule 29 hearing. But for purposes of this court having,
but it did add that element, and sort of just in passing, and told them it couldn't be a commercial transaction. And
yes, it did instruct the jury that a legal commercial transaction was an element that the government had to disprove to get a conviction. Under Masaccio, of course, when conducting a sufficiency review, the court disregards any erroneously heightened elements. However, for purposes of the law in this area going forward, given that 951 is not an often charged statute, the government thought it was important to present this court with its view of what the correct standard for a sufficiency review would be. In particular, our view is that because there's no indicia that the common law was the area from which Congress drew a concept of an agent of a foreign government, or the definition that it added to the statute in 1984, that it's improper to import inopposite civil law concept of agency into the statute. And I think our two best cases for this are food marketing and Brucewitz, where the Supreme Court said that just because words in a statute bear some resemblance to a common law concept, yes, Judge Green.
Ms. Grano, let's just say we agree with you that this is not an element of the crime. Where does that lead us in terms of analyzing the sufficiency of the evidence?
Sure. I think it depends on how far you agree with us, Your Honor. If you agree with us that no civil law agency goes into it, and agree with us that the agree to operate in the United States language refers only to a unilateral intent, I think that seriously vitiates the district court's sufficiency.
Okay, it looks like I short-circuited you a bit then. Please,
no.
Please go ahead.
So there's two.
I don't fully understand why you're so afraid of the common law of agency. I mean, the common law of agency includes any person who does something for another person for a specified purpose to obtain the purpose for the original person. It does also contain master-servant concepts, which are much higher control. But it seems to me, if you have to run into the common law of agency, other than the ordinary sense of what it means to be an agent, it doesn't go one way or other. It doesn't seem to implicate anything here, because clearly the allegation that you make is that the Flynn firm was hired to accomplish a purpose by the Turkish government, and was hired and paid a fee for that purpose. And so somehow everybody got involved in notions of, well, I don't know quite what, but It seems to me the question is whether the jury was properly instructed on that and whether there is sufficient evidence to find that.
I think that's correct, Your Honor. And there's the jury instruction is only as to the legal commercial transaction, which we do think is an important thing to clarify. So maybe I'll move to that next. Based on this court's precedent in Royal, the statutes are almost identical except for the comma and the period distinction. And so we do think that when conducting the sufficiency review, this court should focus on just the definition of an agent of a foreign government, leaving out the core exclusions underneath the statute. Assuming the court agrees with us on all of those points, we think the evidence is more than sufficient. The defendant's arguments really focus on taking circumstantial evidence and separating it out from the overall fabric of the case. Most of the arguments deal with when a particular rationale or an explanation was given. There's contemporaneous documentation showing that that wasn't how it was characterized at the time. In some cases, there's emails directly contradicting the statements that Mr. Rafikian or Mr. Alptekin communicated to Covington lawyers in the investigation leading up to the filing of the FARA letter. And in all of these cases, we think this is a paradigmatic example of the jury weighing competing credibility and inferences about whether or not a defendant's sort of self-exculpatory explanations for his conduct are believable or not. And based on that, this is a paradigmatic example of a case in which resolving those inferences are left to the jury. If the court has no questions on those, I'll move to some of the new trial orders.
Let me ask you one question regarding the unilateral agent proposition you put forth. Tell me, how do you say someone can unilaterally agree to be an agent?
Well, Your Honor, in civil agency law, of course you can't, but we think that's the wrong standard. But you say, as
well, I don't understand that answer. How can you say that's not so? If I hire a real estate agent to buy a house for me and agree to pay a fee, and the agent does it, that's a unilateral transaction. It depends on the real estate agent's performance.
Well, Your Honor, it has to
These
do
people
with
allegedly, you argue that the Turkish government hired the Flynn firm to accomplish a purpose in exchange for a fee.
Correct,
right?
Your Honor.
So why are we involved in bilateral contracts, unilateral contracts? That's a contract.
Yes, Your Honor. We think that the evidence is sufficient to show that Turkey was acting through Alptekin, and that even on a standard of bilateral assent, we have sufficient evidence in this case.
I don't understand what this bilateral assent. Why are you hesitating on that? If they agreed to pay a fee, that's their side of the agreement. Correct. And on the Flynn side is agreeing to do the work.
Correct, Your Honor.
Right? So what are you getting into some probably inappropriate discussions of bilateral and unilateral? The unilateral contract's fine too. If you climb the flagpole, I'll give you $50. You don't have to climb the flagpole, but if you climb it, I owe you $50.
I apologize, Your Honor. I think I understand where some of the confusion might be coming from. We're not talking about concepts of like promises to pay for performance or bilateral.
Well, that's a bilateral contract.
Yes, Your Honor. What we're talking about is whether or not there needs to be a meeting of the minds that a particular person is going to act as an agent within the meaning of civil agency law. So this would be, for example, the first section of the restatement, that you have to manifest an assent that someone acts on your behalf and then they have to consent to do so. We don't think that's the legal standard. We think the evidence is sufficient to meet that standard if that's the one that the court imposes. But that's different than whether or not contracts are imposing mutual obligations or unilateral obligations.
Why isn't that mutual? Because the hiring of the Flynn firm was in exchange for the payment of a fee. So the assent is one side pays the fee and the other side does the work.
It would be, Your Honor.
Okay. I must say, you have a nice way of derailing everything.
I apologize, Your Honor. It's not my intent.
I have a question, Mr. Grano.
Yes,
do you agree that your conspiracy evidence is a little bit more thin than your evidence on the substantive 951 charge? And I'm not really asking you to concede anything, but that's my concern. That you have a stronger case on the substantive 951, And so when you're discussing the evidence, if you could particularly talk about the object of the conspiracy that you think the evidence supported and go into that in a little bit more detail.
Yes, Your Honor, of course. I do think that the conspiracies stand in a different position. This was charged as a double object conspiracy. And of course, either one would be sufficient to sustain the count. I think the evidence is strongest with respect to the conspiracy to act as an agent of a foreign government, as opposed to the willful misstatement on the FARA, which is the other object. With respect to the agreement to act, I think in this case, a lot of the evidence showing what we might refer to as the bilateral agreement between Turkey and Rafikian to act as their agent is also the very same evidence that shows an agreement between at least Rafikian and Alptekin and potentially Turkey itself and an official on Turkey's behalf to act as an agent in the United States. In this context, I would say a lot of the best evidence is that Alptekin created opportunities for Rafikian to meet with the foreign minister and other cabinet level ministers, at which a statement was made that the Turkish government's goal is to obtain Gulen's extradition. And in this case, then Rafikian went back to FIG and with respect to every communication afterwards, declared that to be their ultimate aim and the purpose of the ultimate opportunity. And then there's all of the discussions between Alptekin and Rafikian with respect to confidentiality. We see the same misstatements and false cover stories repeated between the two of them. Yes, sir.
I'll tell you what I'm concerned with in this case is all of the hearsay that was admitted. I think, Judge Trenga is a good judge, and I think that he really came out of this trial very concerned about the fact that over 100 pages of hearsay evidence not admitted for the truth. And I know the jury was instructed various times, not just once, on how to treat this evidence. How could you tell us how much, or was there evidence outside these hearsay statements, and emphasize for us what it was that established that first object of the conspiracy to act as an agent of the Turkish government?
Yes, Your Honor. So I would say there's some conduct elements that show Alptekin acting in this capacity. These would be the weekly catch-up calls in which the FIG engagement was discussed. Not anything said on the calls offered for the truth of the matter, but the fact that there's an ongoing relationship in which they discuss the engagement, the arrangement of the meeting with the Turkish ministers, the
New York meeting?
Sorry?
You're talking about the New York meeting?
Yes, Your Honor, the September 19th meeting that Alptekin arranged, and then a statement from Rafikian, which is of course permissible for the truth of the matter, that he had a subsequent conversation with Alptekin talking about expectations, trying to manage those, saying we'll deliver what we promise. So I think in conjunction with not just Alptekin statements, which are admissible for what Rafikian knew to be happening or what he understood to be happening, there's other indicia that don't come from Alptekin's own statements that show him participating in Rafikian's actions on behalf of the Turkish government in the United States for this purpose.
Well, there's also the parallel object of trying to get Gulen back to Turkey, and he being the leader of the opposition, and also the disparity in the flow of money coming from Turkey and then returning in small part to Netherlands.
Correct, Your Honor.
Which is indicative of Alptekin acting in a different role than just for himself.
Correct, Your Honor. We think the financial payments with the 20%, what we've termed the kickback back to Alptekin, is extremely probative because as I stand here today, I have not heard an explanation for why a client would pay his employee or his contract firm a certain amount of money and then get 20% back as a consulting fee. And we think that's very strong evidence that Alptekin was acting as an intermediary for another person or another entity. And the other circumstantial evidence in the case, such as the meetings and the purpose of the engagement, indicate that that other person was Turkey. I'm a little bit over my time. If the court has further questions, I'm happy to keep going, but otherwise I'll...
All right, thank you.
Thank you.
All right, we'll hear from Mr. Is it Tice or Teese?
It's Tice.
Tice. Okay, we'll hear from you.
Good afternoon, and may it please the court. James Tice on behalf of the defendant. There was some talk about the standard of agency under this statute, so I'll go right there. The district court correctly held that no reasonable jury could conclude beyond a reasonable doubt without speculating that Rafikian acted as a secret Turkish agent, and that he agreed to operate pursuant to Turkey's direction or subject to its control. Now, the government says that it can use essentially a watered-down definition of agent that dispenses with any requirement of showing any proof that a foreign official was ever involved in the relationship. But that interpretation conflicts with Section 951's text, the regulations, as I'll show, the context and the history, and it would have the effect of criminalizing merely acting in a way that benefits a foreign country, absent proof of any meaningful foreign direction, control.
I guess if I understand your argument, your argument is it's clear that the Flynn group had an arrangement with Aptekin, but that Aptekin was acting on behalf of the government was not clear, and you argue it wasn't even proved. And so really what you're saying is it's not an agency issue, it's whether who was the agent on the other side. Was Aptekin and Nova acting on their own behalf as a private enterprise, or were they acting on behalf of the Turkish government? And there's not sufficient evidence to show they were acting on behalf of the Turkish government or a government official.
That's right,
That's what I think. That's what I understand your argument, isn't it?
That's right, Your Honor. That goes to the substantive point. But sticking with the standard for one moment, and I'm very happy to address the substantive evidence of what the government did or did not prove. But speaking for the standard for a second, the way we understand the government's non-mutuality argument or unilateral argument is that all it needs to prove is that someone was acting essentially consistently for the benefit of a foreign country or a foreign official. You don't actually need to show that a foreign official knew about what was happening. You don't need to show that they consented to it or agreed to it.
Well, just staying with that, I want to grant you your argument on whether the Turkish government was involved. But if you just assume Aptekin was hired the Flynn firm to act as agent for him and his firm, the question there seems to be answered simply by saying, will you do this work for us for a fee? And the other side says yes, and then a fee's paid. It seems to me the one is the agent of the other. Now, that doesn't prove that Aptekin was the agent of the government, but it does prove that the Flynn firm was acting as agent at least for Aptekin. And it could be Aptekin in his own self-interest and his corporate interest, or Aptekin as a go-between with the government. Now, the government's theory is he was acting as a go-between with the Turkish government, and that's the rub in the case. But
I agree, Your Honor, and that's where we think that there simply was no evidence. I mean, I think the district court went through the evidence very carefully and summarized this. I think it's helpful to put it into kind of three categories. First of all, what was the evidence of Turkish involvement? Well, the government did not.
Well, let me ask you on that. Initially, I mean, this is an interesting case because of the way in which it proceeds, almost with stealth, given what was being done. Initially, the project is called Truth. And when it's Truth, your client says, Turkey would have been the client for the project Truth. But then it morphs over into something called Confidence, kind of seamlessly morph into it. And there's all kind of emails, looks a little cryptic to me. But at the end of the day, when you look at this, you've got Aptekin who is out there. He has some reason for doing it, but he doesn't come to testify to this, does he?
He does not, Your Honor. He was charged in the indictment along with my client, therefore essentially guaranteeing that he would not be available to testify in this case. And that's why the government sought to introduce his evidence under the hearsay, and one of the hearsay exceptions the district court found by preponderance of the evidence that no such conspiracy was proven. To your point about,
but surely, if you could have, if the government had done something like given immunity or there's some other way, maybe get a pardon or whatever, then he wouldn't have that, and he testified that from your perspective that would be it wouldn't be hearsay anymore. Let's put it that way. The evidence of whether he did it.
We agree with that, Your Honor. You know, and you mentioned pardon. Obviously, that's exactly what happened to the owner of the Flynn Intel Group, who was the leader of this engagement. The government had taken the position that he was not a co-conspirator at all until about a month before trial, when it flipped positions, when it found out.
It flipped his position after he recanted some statements. He went and got him some lawyers and recanted statements. And when you went to trial, I don't quite understand how that all comes up. The government does stuff, and of course now we see this in all kind of cases. I mean, it's interesting the way we are analyzing, or you're analyzing, look at this case and the way we look at it. But I mean, the way in which these cases go, I mean, you got money laundering cases, RICO cases, all kind of cases in which the white collar cases are like this, and then even the lower level. And so when you get in the business of, you know, should the court have allowed, you know, this evidence against that one to then been brought in? You know, when you got evidence he's recanted, you can't bring him in as a witness because he's taking his statements back after he's gotten counsel and stuff or whatever. I explain that soliloquy. I don't quite understand what happened there.
Well, the sequence of events, Your Honor, was that he, according to the government's representations in other courts, he refused to testify the way that the government had expected him to, at which point they decided not to bring him. Since then, of course, the United States government has moved to dismiss his indictment on unrelated charges, saying it never should have been brought post his guilty plea, and now he's been pardoned. But we're getting off track a little bit.
So I guess, let me ask you, if this case did go back for a new trial, you could call that witness now.
Potentially, Your Honor. We could not have called him before, presumably, because he would have taken the fifth, but potentially now that he's been pardoned. But I don't think it's necessary to return this case for a new trial because the government's evidence was, as the district court said, extremely speculative and entirely circumstantial. And if I can speak briefly about
but now the circumstantial aspect of evidence like this, when I think about a case like this, and if you wanted to draw up a blueprint for how to do something like this, it would be in this kind of a manner where you would never ever make that connection directly, but you would use code words or you would say it in a encrypted way, and ultimately you couldn't make the connection, but you could do everything that would be just a substantive crime, but you couldn't make that connection because it's going to be hearsay if you can't get someone other than the person who's alleged to be representing the country to testify.
Well, I'd like to make 2 points in response to that, Your Honor, if you'll allow me. The first is that
Please.
There's different kinds of circumstantial evidence. There's circumstantial evidence such as if the government had presented evidence that Turkey had actually funded this agreement. That would be circumstantial evidence that Mr. Afikian had agreed to operate as a foreign agent. But they didn't do that. They didn't put on any evidence of where that funding came other than from the person that everyone testified was the client. Okay, so
they probably won't ever get that. You're not going to get a foreign country to come up here and say we actually gave it. It's going to be someone put forth in this manner who will come forth and actually take actions, and all you're going to get is that we have officials, a high level officials type stuff. Well, I mean, I just don't foresee a country of this sort that's going to give you direct evidence. That's not diplomatically good.
Well, there is manners of getting evidence. In fact, the government did get evidence from the government of the Netherlands in this case. It just didn't do so from Turkey, and that's at JA 9.
But didn't we get just that with that meeting up in New York? I mean, they all met up there in New York. They got together in a room and they didn't get up there just to have drinks and have a good time. They were actually meeting with Turkish officials, weren't they?
They were, Your Honor, but if you actually look at the pages that discuss that meeting, I mean, just to take a step back, it's clear that Mr. Rafikian and the Flynn Intel Group are seeking to be retained by Turkey in the beginning of August. Okay, it doesn't work out. They end up being retained by a private company instead, and that's what the evidence consistently shows after that. Now, the government suggests that this meeting, which was disclosed in the FARA filing as background for the project they were working on, shows that.
Well, you disclosed it in the FARA filing, which you characterize as being late, which, you know, there's a history there too, because instead of doing it from the beginning, you went under a Lobbying Disclosure Act or something, which didn't require you to do certain things. And then all of a sudden, when you get the law firm involved, you do it late, you now disclose it. But the truth of the matter is, except I guess for the safe harbor language within the FARA the Agents Act, I thought it required you to file it within 10 days of taking these acts.
Well, the Lobbying Disclosure Act, Your Honor, satisfies any sort of FARA and Section 951 obligation as long as a foreign nation is not a principal beneficiary. So, it was only late once Covington made.
But I mean, that's part of the conscious choice. You knew that this FARA would potentially you all notice you had a lot of warning that needs to be done, but you didn't want to be seen. You didn't want it to be known. So the way to kind of hide it, I guess, was to put it as a lobbyist. But there was never any lobbying act done, was it?
Well, Your
I mean,
Honor,
really, in terms of the substantive part of the Lobbying Disclosure Act, there was no lobbying ever done, was it?
there was a small amount of lobbying done. The government never charged us with an LDA violation or anything of that sort.
Oh, I got that.
Let me certainly.
Go ahead, Judge. I'm sorry.
Mr. Tice, both Confidence and Truth, the projects listed as their primary object was to paint Gulen in a negative light and to achieve his extradition back to Turkey. And it looked like throughout this, your client was not being straightforward regarding whether Truth and Confidence were actually the same project. In his statements to the Covington lawyers and other statements, there was a suggestion that they were entirely separate, okay? But they had the same phase 0 action plan that showed that in fact they were, or at least arguably, a trier of fact could find that they were the same. So it looks like there were conflicting circumstances in your client's posture that he was taking from which the jury could conclude he wasn't being truthful. Isn't that part of the fact finder's role as well, to assess whether these explanations wash with the rest of the circumstantial evidence in the case? I mean, I agree with you, it's a flawless case, but...
Well, I just want to be perfectly clear, Your Honor. There was no such thing as Project Truth. It never came to fruition. Essentially, Altikin was seeking to... Flynn Intel Group was looking for a new client. Altikin was looking for someone to work with. He was negotiating with the Flynn Intel Group about getting the project off the ground. Project Truth
started the same day that Truth was abandoned. Is that correct?
They decided to move forward under the project with a different client. There was no evidence put in that Turkey was that client. There was no evidence that suggested that Turkey was paying for the engagement, that it was passing along any instructions, that it was making any requests. The district court.
I'm sorry, but Mr. Tyson, then I won't interrupt you again, but my point is that it looks like Mr. Rafikian was giving different versions. He was arguing that Confidence was entirely separate from Truth, but it showed that the objectives that were being advanced were the same. There was other evidence. So was going back to my question from before, wasn't the trier of fact entitled to say, wait a minute, something is wrong here? He was lying about this because we've seen this phase 0 action item from Truth, and we've heard about Confidence too, and these things are essentially the same.
Well, I think, thank you, Your Honor. I mean, I think in terms of whether or not the jury could have made such an inference, I think the answer is no, because juries are allowed to make logical inferences based on circumstantial evidence. I agree that circumstantial evidence and even false statements are evidence.
But they do it all the time. They do it all the time. You've got an instance here where applicant is the same intermediary for both of these.
But the district court,
and you do it the same day. You got the same purpose. And if you're going to do a case like this, I'm thinking these are not easy cases to prove. I'm thinking you got to rely upon reasonable inferences. Very seldom you're going to get the agent to come up and testify. The country has told me to do something, and therefore I'm working with them. If you're going to do it, it's going to happen in this way. So when you give this to the jury, and he says, well, you got this Truth project that you say didn't exist, but that's a pretty strong thing because that looks pretty bad. So you separate yourself from that and says we got the Confidence, which is a separate thing, but it's the same guy, and you're doing the same stuff. So the only difference is now you've maybe divorced yourself from this opportunity or this now what we call an obligation to go and report this thing to the Department of Justice, which apparently you didn't want to do until after you got counsel somewhere down the road and finally did a late filing of that. So, I mean, there's a reason for all of this. If you want to do this kind of work and you want to do it in a clandestine or under the table sort of way, you want to try to avoid such things as coming, put into the Department of Justice, because those guys over there do a serious investigation on you when you start doing that. So you probably don't want them to know about it. Well, I don't see how you say the jury couldn't connect the two. I mean, certainly there's evidence to say they weren't, but in the cases like this, when we're looking at it, we rely upon reasonable inferences.
And the district court went through all this evidence and sat through this trial and said that these were not reasonable inferences, that they were too speculative. If you don't mind, I'd like to make a quick point about FARA, Judge Wynn, because I think you brought up an interesting point, which you said these are tough cases to bring and tough cases to prove. And I think that's right. There's only been 3 cases in the entire history of the Fourth Circuit that have even cited this section. All of them involved espionage-related allegations, conspiracy to pass along classified information to known foreign officials. In each of those cases,
you don't think that you don't just because you've only had 3 cases, you don't think in the history of this country there's only been 3 incidents of it, do you? It may be a hard thing to prove, but
of course not.
I don't think that tells us anything if you only got 3 convictions in it. But I think that the issue here in this case is whether we've got the evidence was sufficient for it to happen in a case like this.
And my point is, Your Honor, the government says, well, can have this agency definition that you don't need to show the involvement of any foreign official. You can just say, well, there was a lot of suspicious behavior. He was acting seemingly on behalf of a foreign government, but there's no actual evidence of an agreement or instructions or requests made by the foreign government. And what I'm saying is, in the other Section 951 cases, the only 3 that this court has cited, all 3 of them did involve espionage-related activities that did involve requests, instructions, direct communication with foreign officials.
Can I ask you, when did the Turkey make a formal request for the return of Gulen in relationship to the formation of Truth in this case?
I believe, Your Honor, it was shortly after the extradition. Shortly after the coup attempt.
Turkey was already on public record requesting return of Gulen.
Very much so, Your Honor. And in fact, Turkey.
So now we have this engagement in Truth, which is to turn the American government against Gulen to facilitate his return.
Yes, and one of the
6 days later. 6 days later, right?
Turkey actually contemporaneously hired another agent, an actual agent, Robert Amsterdam, and Associates, his law firm, to do exactly what Mr. Alptekin was trying to convince the Turkish government to do with my client.
Yeah, but there are different methods. There are different methods for doing things, different avenues. And if you had 3 or 4, you'd follow all 3 or 4 if you were the Turkish government. This was a big deal to get legitimacy. And here you have Truth hired specifically to assist the object that Turkey had announced publicly.
Well,
and then that engagement lasts for a few days and is only between Reptigan, Flynn, and Aptekin. That's the only 3 to the Truth thing. They have exchanges of what they're going to do, what they propose to do. They have the acceptance of the engagement. And then at the next steps, the email said, we now get our firm operated. On that very day, they changed the name to Confidence and started using very generic terms about what they're engaged in. But the purpose remained the same, as far as I can tell.
Your Honor, I would just briefly say, just acting on behalf of a foreign country, not under the direction and control, does not satisfy the statutory standard.
No, it's part of the circumstantial evidence. The question, one of the big questions is whether Truth and Confidence were one and the same, and if they were, was Truth sufficiently connected to the Turkey through these coincidental facts? They were trying to get Gulen back. They were trying to disengage Gulen. They were trying to get the government and the president saying, "Oh, Gulen really is a bad guy. He's a terrorist, and you ought to turn him back." It seems to me the parallel projects are part of the coincidental, part of the circumstantial evidence. And we talked about this other evidence of the meeting in New York and the payment of funds from a Turkish bank with a kickback going to a Netherlands bank. It's all a little funny.
Well, Your Honor, that was the government strategy at trial to suggest there was a lot of funny things going on. But ultimately, they didn't show that he was acting on Turkey's direction or Turkey's control, because that would require showing that some foreign official was actually involved in passing along instructions. And on this point, I think it's really significant, Your Honor. That
the question you have to ask on that line, the question you have to ask is whether Aptekin was acting on Turkey's behalf as its go-between. Because yes. Aptekin did reject some steps being taken and did approve some other steps being taken, and he did so in the name of Turkey. And so he could be self-promoting, there's no question, but you have to put all this together.
As the government admitted below, though, it would depend on the nature of the agreement. Even if Turkey had hired Aptekin, and the jury could have inferred that to be the case, it would still depend. At JA 2071 and also at JA 111 and 112, the government conceded below that you still need evidence that the defendant knew that Turkey was actually operating behind Aptekin and that he agreed to operate in that context. And on this point, I think it's really important to point to the fact that FARA actually does mimic the sort of theory that the government has here about Section 951. Section 951 says agent of a foreign government. You have to act at the direction and control of a foreign government. But FARA is much broader. It says you can be a representative, not just an agent. You can operate at a request, not just under the direction or control, and you can do it indirectly, not just for the primary benefit of someone. So the government, for whatever reason, did not charge a substantive FARA offense. That would have been presumably the simpler crime to charge here if it really thought that Turkey was behind all of this. Instead, it chose to accuse my client of being a secret Turkish agent operating in this clandestine manner. And if it turns out that it hasn't satisfied its burden of proof by actually showing any direction and control from the Turkish side, well, then that means the judgments of acquittal should be affirmed. Now, I know I'm a little bit over my time.
Can you, if you will, answer one question I just would like to get your response to, and that is, how do you view this 20% fee, this commission that was paid? Looks like a commission. How do you view that?
I'm happy to address that, Your Honor. The record evidence was that everybody everyone who testified said that they understood the project was being funded by Turkish businessmen. That came up throughout the record. So there was never any doubt that Aptekin was not paying out of his own pocket. He was trying to hook up the Flynn Intel Group with paying clients. When it fell through with Turkey, he got some of his Turkish businessmen to pay for it. And that explains the payment, Your Honor. He was, at the end of the day, he was trying to get this project off the ground. He is a. So
are you saying that 20% was a commission?
I think it was described in the FARA filing that went to the government as consulting payments. I don't think it was a commission. That's how they structured it in their formal agreements. But, Your Honor, I think I'd be remiss, the government, and I think some of the questions today have gone to what are the sort of reasonable or permissible inferences that could be drawn here, even if you might disagree with them, could the jury? Well, that goes directly to the new trial ground on the sufficiency of the evidence. In that case, as both the Campbell case and the Souter case found, that is permissible for the district judge to, based on his own view of the record, seeing how this affected the jury over a 6-day trial under an abuse of discretion standard, he is allowed to make those inferences. And again, that's exactly what the Campbell case says, that if the error the district court made was improper inferences, well, he's allowed to do that in the rare case. And I should note that he noticed page 2149 of the JA that this was rare circumstances. So he well understood that it's a rare remedy to grant a new trial on that weight of sufficiency. But at the end of the day, I would say clearly this judge who's experienced, who saw this trial, thought something went wrong here based on the presentation of the evidence, the position with respect to Flynn, all of the hearsay evidence that came in, Your Honor. And I think, again, it's really worth emphasizing that most of the evidence in the case, essentially all communications with Aptekin, were not admitted for their truth. It was nearly 100 pages. And I think it's well within a district court's discretion to say, a new trial is necessary in that circumstance when he in his experienced judgment and discretion, determines that it affected the rights of my client. Happy to answer.
All right, thank you. Thank you. I see our time is over, and we'll hear now from Mr. Grano.
Thank you, Your Honor. I'd like to start by addressing some of the evidentiary points because I think the court has really honed in on the key elements of the circumstantial inquiry here. I'd emphasize, particularly, there's an email from Mr. Rafikian in which he says, after the project is named Confidence, we have been at work on this engagement since July 31st. So that is a direct statement by the defendant that he viewed these as being the same project, starting, as Judge Wynn pointed out, 6 days after OIA denied the extradition request is when Alptekin reached out to Rafikian and started this entire process. And it's not just that they had the same objectives, as Judge Keaton pointed out. They had the same playbook, they had the same budget, the same 20% was in both the truth budget and the confidence budget. The New York City meeting occurred after the transition to confidence. And so you have a Turkish official meeting at Alptekin's instigation with FIG, announcing their goal, we want Gulen extradited to Turkey. And then you have Rafikian leaving that meeting and communicating to the rest of his team that that is what their ultimate aim is. We also have the false statements from Mr. Rafikian to the Covington lawyers after he was given an Upjohn warning, and the jury heard testimony about what an Upjohn warning is, and can conclude that he knew that this was dicey territory and started distancing himself from what he thought Covington might figure out about all of this, and then didn't turn over all of the Skype communications with Alptekin on this subject. We also have some independent indications that Alptekin was working on Turkey's behalf. In addition to the meeting, I'd point out that following the sort of disastrous meeting in Alexandria, Sphere Consulting, who was a FIG subcontractor on this, reached out to Alptekin with a public relations proposal for the Turkish government. And Alptekin, even though a bidding process had closed already, got them a late entry with the Turkish embassy where they met with Turkey's #2 diplomatic officer in the United States. I think these are all indications that the jury can use to draw on the fact that there was, in fact, a Turkey-Alptekin link that continued through the FIG engagement. I'd also point out, again, that when asked about these 20% statements, the story that both Rafikian and Alptekin told was that these were refunds, even though no contemporaneous documentation established this fact, even though they were consistently characterized throughout the entire process as consulting fees. So this is, again, as Judge Keenan pointed out, a falsehood that the jury can then infer guilty knowledge and guilty intent from. I'll turn next to the hearsay evidence, and so a point that Mr. Tice just concluded with, which is he said earlier that one of the key things we didn't prove was that Rafikian knew Turkey was behind Alptekin. But that's one of the key things that the Alptekin statements are permissible for, not for hearsay, but that he was told about Turkey's extensive involvement in it. Now, while we can't rely on those statements under the district court's limiting instructions to prove that Turkey was in fact behind Alptekin, we can certainly rely on them for their impact on Rafikian's state of mind, particularly coupled with all of the indications that Turkey was actually involved, including the September 19th meeting. Lastly, I'll just touch on the new trial on the weight of the evidence order. We don't disagree that a trial judge is given deference in a new trial weight of the evidence context. The problem here is that, in our view, the district court had already committed multiple legal errors on the standards for the substantive offenses, and then also didn't cite the governing standards for purposes of a weight of the evidence new trial order. As this court most recently pointed out in Chavez, mere disagreement with the jury's verdict or mere belief that the credibility determination should have been resolved a different way is not sufficient. Rather, the standard from Arrington since 1985 has been that the evidence must weigh so heavily against the verdict that it would be unjust to enter a judgment of conviction. And we saw no engagement from the district court on that standard and no explanation of how, while he might disagree with some of the jury's inferences, it crossed that extra additional threshold. And so we think that was an abuse of discretion.
All right. Thank you. Your arguments were informative and helpful, both of them. And this is a very involved case, and we thank you for your arguments. Our practice at this point would be to come down and shake your hands, and I particularly missed doing that today in view of the long work and the long involvement in this case, which is was hard for you guys, and it's going to be hard for us too. but we extend our greetings and as if we were shaking your hands, and thank you for your arguments. We'll proceed on to the last case. All right, we have Mr. Jones. Can you hear me? Can you unmute yourself? I can't hear you.
How about now, sir?
Fine, perfect. And Mr. Joseph?
Yes, sir, Your Honor, I'm here.
Okay, we hear you both. We'll proceed with the United States versus White, and Mr. Jones, we'll hear from you first.
Thank you, Your Honor, and may it please the court, Mark Jones for Terry Antonio White. The common law of England, as inherited, adopted, and maintained by Virginia, contains a notable exception to the force or intimidation prong of common law robbery, such that Virginia common law robbery is not a crime of violence for ACCA purposes, and therefore Stokeling does not abrogate this court's decision in Winston. The first principle that is important to keep in mind here is provided by statute, and it's Article 1, Section 20 of the Virginia Code. And I want to read it because it's important, and it states that the common law of England, insofar as not repugnant to the principles of the Bill of Rights and the Constitution of this Commonwealth, shall continue in full force within the same, and be the rule of decision except as altered by the General Assembly. Since the Revolution, no appellate court in Virginia has challenged or even questioned the crimen innominatum exception to the force and intimidation prong of common law robbery. In Houston in 1890, the Supreme Court of Virginia had no problem saying that this is a part of the common law of Virginia, and it had no difficulty doing that despite the fact that there were no prior Virginia precedents saying that it was part of the Virginia common law, despite the fact that there were plenty of cases before Houston in which the case had discussed the elements of common law robbery, and that there were no appellate decisions at the time in which the exception had been specifically discussed or applied to the facts. Again, in the next century, in 3 cases in 3 years, these are the Maxwell, Fleming, and Falden decisions, the court again had no difficulty saying that this exception is part of Virginia's common law, despite intervening cases in which the common law robbery elements had been discussed without referencing the exception. And again, despite the fact that there was not appellate evidence that there had been a prosecution on the basis of that exception since the Houston case. It simply makes no difference that Houston, Maxwell, Falden, and Fleming, that these were not cases that involved a prosecution on the basis of the exception. That argument, right, that this exception is dicta in Virginia is a red herring, and that's because Virginia follows the common law, not bits and pieces. Yes, Your Honor.
Mr. Jones?
Go ahead.
Oh, I'm sorry, Judge Niemeyer, you go ahead.
No, go ahead.
Okay. Mr. Jones, this argument wasn't made in Winston. You're aware of that, right?
Yes, yes, Your Honor.
So this really is, I think, the first time an appellate court has had the opportunity to consider this issue in the context of common law robbery in Virginia. And I've been struggling whether this is a case that would be one for certification to the Virginia Supreme Court, because we would be deciding what the law is in Virginia when Virginia hasn't spoken on it since 1938. And I agree with you, just because it hasn't spoken on it since 1938 doesn't mean it's not the law. In fact, when I was on the Supreme Court of Virginia, the judges used to say the older the better, okay? So, but my concern is here that we now have from the US Supreme Court a decision that says, Lawrence versus Texas, that says sodomy without more is not a crime, okay? So how does that impact your analysis? Does it really take away your argument that this is a viable way of committing common law robbery in Virginia? And should we even trouble the Virginia Supreme Court about it?
I think potentially we should trouble the Supreme Court of Virginia about it. And I don't think that Lawrence versus Texas changes our analysis. Sodomy is not an archaic phrase. I mean, it is one that is continually in use in the Virginia codes. And even in 2015, in the Tog Hill decision, which is in my brief, they describe Virginia's broadly worded anti-sodomy law. And so sodomy is not just the conduct that was protected by Lawrence, but it's a number of practices which are still criminal in Virginia. And so the purpose and the impetus behind having this exception in the common law robbery jurisprudence still exists today.
Right, but those are mostly sodomy plus. In other words, sodomy involving a minor or sodomy, whatever. Can you give us an example of, I don't want to say just plain sodomy, but can you give us an example of sodomy without plus that is still a crime in Virginia?
No, certainly the conduct that if you use the word sodomy just to mean the conduct that was deemed protected in Lawrence versus Texas, the answer to that is no. But I don't believe that the common law use of that phrase swept that narrowly, and that's the reason why.
Well, let me ask you. Let's assume you're absolutely right. The robbery was taking property by force or by threatening to charge or whatever, attack the reputation of somebody in this with sodomy and that type of thing. Let's assume that's still continued in the common law. It looks like Virginia took robbery and broke it into two prongs, still using the common law terms because Virginia still does. And in 258, characterized it basically by force as recognized by the Supreme Court in Stokely, and in 2-59 created the sodomy robbery. They called it extortion, but they used all the very same language, taking property by threatening somebody's reputation, an offense of being illegally doing this or illegally doing that. And I'm wondering how Virginia's codification, its split up of the common law like that affects your analysis for this case, which came after those statutes were enacted.
Yes, Your Honor. I think it's a mistake to read 18.2-59 as a codification of this exception to the robbery common law crime. I understand 18.259 simply to be the punishment for what was common law extortion. At common law.
Excuse me, Mr. Jones, aren't both of those punishment sections? They don't define the crime.
That's correct, but both extortion and
the Supreme Court has really been on record that those are punishment sections. Isn't that correct? So how does that affect your argument here?
Well, so first to say that there is common law extortion and there is common law robbery. And if the legislature was going to excise this version of extortion from robbery and now put it underneath this extortion punishment statute, the Supreme Court of Virginia tells us that there must be clear legislative intent to do so, and that intent must be plainly manifest. And so from what I'm reading here, it seems you're really relying in terms of a strict application of the law as it is. I mean, in terms of whether anyone would ever be charged with this, that's kind of out of the window. Judge Keenan's alluded to that. But I think the question, as Judge Niemeyer has put it, is you really don't need a criminal act here. You're talking about fear of telling someone that you engage in sodomy that could support common law robbery. That doesn't have to be a crime. Not the crime. The crime of sodomy doesn't have to be a crime. It's just a reputation. Would you do it to keep someone from telling that you've engaged in sodomy? That's a whole different thing. And the question of whether to certify it to the Supreme Court, I mean, it sounds good to me, but it seems like the certification would be Supreme Court of Virginia. Why don't you overrule those cases that you got on the book up there? That doesn't sound like a clarification of law. Those cases are there. They've had a chance to overrule the legislature.
It's an interesting thing, but I don't think we're talking about extortion here. We're talking about a different type of robbery, and that arises from this exception. And the question is, this exception, because it's old. You got Lawrence versus Tech. Nobody thinks it's worth anything. But could you rob someone in doing it? Now, let me move to another question, because I think this is where Judge Niemeyer is going. It looks like this is a categorical approach that we're taking here. If we for somehow got it to be the modified one, isn't this a divisible situation here?
So to work backwards, no, I don't think this is divisible. I think under Vincent, you would say that there are different means.
But if it is, you lose, don't you?
I don't know that has been fully briefed, Your Honor, and so I'm not prepared to.
It's not been briefed at all from what I can see, but I'm just trying to understand how it works, and I don't know why it wasn't brought up.
It was argued below always on the strict categorical approach, and I do think Mr. White's safe under modified categorical approach. But if I could turn back to your first question, I think the question for certification would be whether or not there has been judicial abrogation of the common law, or whether or not there has been legislative abrogation of the common law. And I think it's set forth pretty clearly in my brief. I don't think there's any case to be made that there's been judicial abrogation. And then I think as to legislative abrogation, you have to look to whether it's the Supreme Court of Virginia or this court, look to what the standards are as set by the Supreme Court of Virginia. And the Supreme Court in Virginia has set an incredibly high bar for measuring whether or not there has been clear legislative intent to abrogate a common law crime. And
well, you kind of walked us through that starting. You took us from England, common law, all the way up to understand how Virginia look at these things and how they set the law and make it very difficult for you to do things otherwise. That's why I think Judge Keenan is right. If you want to do something with this, you'd have to go back to the Supreme Court of Virginia and ask them to clarify. But again, I'm not sure it's a clarification. It's hey, we all know that you ought to overrule this thing. Why don't you just go ahead and overrule those cases or go differently on it? So I don't know.
I think Judge Wynn, there may be a different answer, and this also I believe goes to Judge Niemeyer's question: is hasn't the statute, 18.2, 16, 18.2, 58, 59, hasn't that been a legislative abrogation of the common law? And
I didn't suggest that, sir. Okay. I suggested they bifurcated the common law, separating 8 from 9. They're both common law-based crimes, no abrogation, but they put them with different penalties in different sections. And as a consequence, the Supreme Court of Virginia regularly, probably a dozen times, has defined robbery in Virginia now as the taking with intent to steal of personal property of another from his person or his presence against his will, by violence, or intimidation. And then they have defined intimidation under that, which is the only one available for a nonviolent, as to take or attempt by intimidation means willfully to take or attempt by putting in fear of bodily harm. And they go on and explain that further, placing the victim in fear of bodily harm, and they've cited several cases for that. So my whole point is that the 2-58 categorically says taking a property by intimidation, which the court hasn't construed to mean intimidation of putting somebody in fear of physical harm. And of course, that's almost verbatim what the Supreme Court in Stokeling said was a classical force clause.
Yes, Your Honor. In a case my answer to that wasn't clear, the common law had common law robbery, which included this exception, and it also had extortion. And so 18-259, I think, is best read as simply the punishment for the other versions of common law extortion, and it isn't limited to this scenario. But
it's not limited, but includes it. In other words, the language of 59, 2-.59, includes the taking of property by threatening somebody with sodomy or whatever reputational thing. And so my whole point is, really, if we look at what the Supreme Court is saying about its own law now, Virginia, and how they've construed it. I was just reading from Bivens versus Commonwealth. That wasn't, that was a 1995 decision. They were explaining what the intimidation was. And the intimidation is putting somebody in fear of bodily harm. And so it seems to me, then you're stuck under Stokeling, under categorical approach. What happened with the Houston formulation, it's not gone. It's taken up. You threaten somebody with charging him with sodomy is taken up in 59. They do call it extortion, but they mix it in with all the aspects that cause extortion. But that's included.
I think to do so, Your Honor, that would be essentially an abrogation of the common law formulation of common law robbery. And to have done that, it would be judicial abrogation or judicial modification, essentially excising that exception from.
Well, let me ask you then. I hear your point, and I'm not sure it's an abrogation. I think it's a splitting up. But let's set that aside for a moment. How do we handle the Supreme Court's statement? The only gate you can go through is taking property by intimidation. And intimidation, they have specifically defined as putting somebody in fear of bodily harm. Now, how do we handle that? That seems to me that they do not say threatening somebody to charge him with sodomy.
So I think the statement from Bivens and from lots of current cases, both the Virginia Supreme Court and the Court of Appeals, are statements of the elements, and they simply are not stating the existence of the exception, just like there were cases between Houston and 1930s that stated the elements without noting the exception, and just like there have been cases since then between the two sets of cases that didn't state it. That is a statement of the law as necessary for those cases, and I don't think that we should read into it that Virginia longer.
I don't think they limit it to those cases. They're stating the elements. They're stating the elements of the offense and defining those elements. And under the categorical approach, we look at the elements and the fact of conviction.
I think it's also, I believe, Your Honor, it is also true we have to look at the rest of the common law, which informs exceptions to those elements. And so I think the Virginia Supreme Court, through Houston, through Maxwell, Fleming, and Faulding, has already answered that question as to whether or not it remains a part of the Virginia common law.
But I think just to be clear, so that I understand it, it seems to me Judge Niemeyer is correct insofar as that 1-200 requires, but 1-200 does require explicit abrogation, not this sub-salential type abrogation. And the problem here, of course, it goes back to the cases. I mean, you got a state Supreme Court in 3 cases that says it right on point, and they haven't abrogated it, nor has the legislature. So we as an appellate court on the federal side dealing with a state law in which they pretty much have said what the law is. Oh yeah, it certainly looks like that, but they haven't done that. And it may be reasonable to read the sentencing statutes and things of that nature in the manner that we're doing it, but it's the state Supreme Court that said it, and it has not overruled it nor abrogated it, nor has the legislature.
No, I
that
agree.
makes it part of common law. I mean, and the question of Lawrence v. Texas, very good question, but I think you could, it looks clear to me, you could violate this with fear. This thing says fear of a threatened in terms of sodomy. It didn't say sodomy was a crime. It didn't say the government was charging them. That wouldn't make any sense. The government would go out and create robbery by threatening, I'm going to charge you with it. It's somebody out there saying, I'm going to go out and do this. I think there are plenty of people that would submit to robbery who, if you put them, a lot of people who probably feel like that's not something I want you to do, and I will give it to you or whatever under that threat. But I'm just saying that everything I'm hearing sounds good, but the way Virginia structures its law and how you can abrogate stuff, and this does require explicit abrogation, it looks like Virginia ought to change some laws.
And that, I think that really is the question, is what is the state of the law in Virginia, and has judicial silence about the exception, despite recognizing it previously, and no explicit discussion of it in its statute, is that sufficient given Virginia's commitment to the common law? Is that enough, that this court, this federal court, could now and should now say that no, the state of the law in Virginia is as the government suggests? I see my opening time has expired.
All right. Mr. Joseph, I guess we'll hear from you.
Thank you, Your Honor. I noticed the time of the day. I'll try to make it brief and to the point. I would say that what the defendant is relying upon on these cases, Virginia has not applied the rule that the defendant so earnestly asserts. Houston was a case of an assault on somebody by use of a firearm. Maxwell was robbery of a Western Union telegraph clerk. Fleming, robbery of two boys fishing of their frogs and their guns. Falden, conspiracy to rob a U.S. mail truck. When you
But they don't really have to, you don't really have to apply it under our law. We had an en banc case recently. This Aparicio case pretty much answers that. And it just says, you don't need legal imagination. If the state Supreme Court has said it, then we don't get in this possibility stuff. And I grant it, it's an old case. And I also granted, I don't think they will ever do it. But I'm looking at this case, and if we do that, then I don't think we can reimagine how this thing can be applied even after launch, because the state Supreme Court has said it. And you tell me what has abrogated the state Supreme Court's decision, not the legislature. So who has done it?
What I'm saying is dicta. That is the Virginia Court of Appeals.
What's dicta? What was dicta?
Dicta is defined in Newman versus Newman, 42 Virginia Appellate 557 at 564. Dicta in a prior decision refers to that portion of an opinion, quote, not essential to the disposition of the case. And that's all this is. It's dicta.
So your position is that Virginia has never really had a case on point recognized this
exactly right.
as a I must be reading those cases quite differently, because I thought they said it. You can call it dicta or whatever you want to do. It's the Supreme Court of Virginia.
Yes,
it's pretty strong stuff. It said it.
But it's dicta, and I would submit that really we're talking about the categorical approach, as one of your Honor has said. And the categorical approach under Gonzalez versus Duenas Alvarez, 549 U.S. 183 at 193, the defendant has to show not just legal imagination, but the defendant has to show that he or somebody else has actually been prosecuted. A realistic probability, not just a theoretical possibility. And I submit that under Moncrief, this is not an invitation. It's not an invitation to use legal imagination.
Okay, yes, Keena is trying to get your attention.
Yes, ma'am.
Mr. Joseph, though that will the Moncrief find a case principle or the reasonable possibility of a prosecution doesn't apply where the state, the highest court of the state has made clear that this is a crime. I mean, your argument is really resting on the fact that the state hasn't made clear, isn't it?
That's right. That's right. It's dicta. It is dicta because those cases did not involve any kind of sexual act. There was no homosexual act, no heterosexual act. There was no sex involved in it.
Right.
So what they said was just extra.
But the court took the opportunity to define the crime, didn't it?
They repeated what they thought was the common law or what was applying, but it didn't apply. It was not a holding. What I'm saying to the court is, yeah, they said it, but it wasn't a holding because holdings apply to facts and everything.
But it was a correct holding. I mean, at the time, Virginia adopted the common law of England. And when you go back and look at the common law of England, this is what it did. I think those justices back on the Supreme Court of Virginia knew what they were doing in 1938. That wasn't. I don't know how you say it's dicta when all they're doing is telling us what the common law said. I think that's disrespectful, to be honest with you. It may be a way out of it, but I don't think that's the way out of it to say that these justices were speaking in dicta. And justices of that time period, when I read their opinions, there's some really tight writing that went on back there in those days, and that looks like it's pretty strong law. I'm not saying it still would be, and I'm saying it should be. I'm just saying if you go back, if you start at the beginning and says, well, Virginia Supreme Court, just ignore that. That's dicta. When all they're doing is stating what the common law is, and Virginia has adopted the common law of England, which clearly this is what England recognized, the common law. So I'm not saying, I'm not trying to kill your argument totally, but I'm just saying I don't get that one. That's not the starter I would take on it.
I don't mean any disrespect to any court, especially the Supreme Court of Virginia. I have the highest respect for all courts. So I don't mean any disrespect.
I don't want to imply that you do. I know you to be a very professional person, so don't take that in any way as a personal criticism. I know you would never do that.
Yes, sir, and I would not.
Well, Mr. Joseph, you have some allies because the Supreme Court has repeatedly talked about looking at the prosecutions actually taking place, the jury instructions that are given in trials throughout the state, and the definitions given by the court in ongoing applications. And none of those, we could find not a single case prosecuted under this, and the chances that they would ever be prosecuted. And to say that categorically, therefore, this is not a crime of violence would be speculation, because they recite it as reciting some English law, which mechanically they're supposed to recite, but they have never applied it in Virginia.
Well, yes.
And the Supreme Court of the United States recognizes that as a fatal flaw in establishing the nature of an offense.
And I think it's somewhat noteworthy that the two times this court has talked about Virginia common law robbery in Presley in 1995 and in Winston in 2017, that this wasn't argued. In fact,
nobody brought this up. So we've got it for the first time. Mr. Joseph, what's wrong with certifying the question of whether under Virginia common law robbery can an individual be convicted of common law robbery by means of threatening to report a victim with something? What's wrong with just asking that? You know, you're saying no, can't be anymore. This is old stuff, and opposing counsel is saying, hey, you know, it's consistent. It hasn't been abrogated. What's wrong with asking them to weigh in on it?
What's wrong with it, I submit, is that the defendant, in his brief, note on page 12, note 4, says that the punishment for common law robbery cites the statute that was in the supplemental filing of the government. And the Virginia Supreme Court in Jones and George versus Commonwealth, 242 Virginia, 264 at 277, says the punishment for common law robbery is this statute, 18.2.58. So what I'm saying is that you look at that statute, if that's the punishment for common law robbery, and you look at the statute, and there is no way you can commit that robbery.
It doesn't define. The distinction in Virginia is that the common law is defined by the Supreme Court of Virginia unless otherwise defined by the General Assembly, okay? Another abrogated by the General Assembly and defined by statute. 18.2-58 is a punishment statute. So that does not abrogate the common law. It simply says what the punishment was. And that's what the court said in George versus Commonwealth. It was
Judge Keenan is trying to throw you a line here. What she said, why don't we certify the Supreme Court to someone who can abrogate it? So I don't understand why you would be opposed to that, because I would tend to think they probably going to go in your direction on this here. Maybe you have some reason to believe they wouldn't, or you don't want to put it up for it. I think when you get to the business that, of course, Judge Niemeyer's alluded to the fact it never happened. I agree it hasn't happened, but I don't think you need it. We just had an en banc case that settles that question. If the state Supreme Court has said it, it's done. And you can call it dicta, but there were 4 Supreme Court cases from Virginia on this. Wasn't one little aberration, 4 of them. So I don't know what this 4 dicta type thing, but the Supreme Court stated it. And they were stating what the common law of England was, which Virginia recognized. Judge Keenan says, why don't you certify it to the Supreme Court? Then they can go back and they're the ones can overrule these cases. I'm not saying I'd oppose that. I'm just saying I don't understand why you would say that's not a viable opportunity here.
If the court, thank you, Your Honor. If the court wishes to do that, of course, the court can. My only point is that it's a lot of dicta, and I don't see a punishment. I don't know how you can have a crime without punishment. I don't know how you can have a crime, common law robbery, without punishment. And I think the legislature in 1975, when they enacted the statute, they in effect abrogated the common law. So
In other words, but you could get the conviction. You could get a conviction, but you couldn't get a sentence, anything from it. Is that what you're saying?
What I'm saying is you can't have a crime without punishment. The Supreme Court has said you can't have a crime without punishment. When you look at Judge Brinkema's ruling in Williams versus United States and the Supplemental Authority from May of 27 of this year, May 27th, as she pointed out, she cited a Supreme Court case that said you can't have a crime without punishment. So
that would be a third way to abrogate a statute then in Virginia. You're saying either the Supreme Court can do it, or the legislature can do it, or you can just not have a punishment for it.
Well, that's one way of putting it, Judge. Yes, sir.
I'm just trying to follow out. I'm following Judge Keenan. It sounds like to me she knows a little bit more of Virginia law than I do on it. I thought you could only do it by the Supreme Court and the legislature, but you tell me there's another way to do it.
Well, the legislature, when they enacted the punishment statute, they changed it in 75. That's their action. If there's no punishment, they're saying common law robbery is punishable by this statute. You look at the statute, there's no way to commit common law robbery by threatening sodomy. So my only feeling is, why send this down the street when you've got it, when you can look at it and say, in addition to the, I know we don't want to talk about dicta, but looking at the actual, could this happen, and is this a crime anymore in Virginia? Well, I would say it's not, because you can't be punished for it. So the Virginia Supreme Court has said what the punishment statute is for robbery. And you look at the punishment statute, and I'd say we're done. And
well,
really
although Mr. Joseph, the punishment statute 18.2-58 talks about punishment for robbery by partial strangulation, suffocation, striking or beating, or by other violence to the person, or by assault, or by presenting a firearm or the threat of a firearm. It's not discussing the punishment. It's not purporting, as you say, to discuss the punishment. So how can you say a crime that was punishable at common law that's not referenced in the statute can't be still punished at common law?
My question is,
that's circular that you're saying.
Well, I don't mean a circular argument. Your Honor's been on the Supreme Court of Virginia. You know far more than I do. All I'm saying is, and I acknowledge that, all I'm saying is the Virginia Supreme Court said, look to this statute. That's where the punishment is for robbery. You look at the statute, and it says how punished, and it describes if you have robbery committed in certain ways, this is the punishment. So I don't see a punishment statute. Maybe the defendant does, or maybe Your Honor does, or the court does, and that's fine. But I don't see it. So I don't know why we'd send the case down the street to the Virginia Supreme Court when you can't have a crime without punishment. That's all I have to say. That's really my argument. Thank you for hearing me, unless you have further questions.
All right. Thank you, Mr. Joseph. Mr. Jones?
Thank you, Your Honor. I think it's important to follow up that with looking at what 18.2-16 says. And it says that a common law offense for which punishment is prescribed by statute shall only be punished in the mode so prescribed. And then when you look at 18.258, it lists the prescriptive punishment for 10 different means of committing Virginia common law robbery. It does not say all common law robberies are punished as X, and it says nothing whatsoever about this particular version of common law robbery. And so,
well, if somebody commits this version of common law robbery, what's the sentence?
I would suspect that it is a common law punishment known to the jurists of Virginia. All the more reason to send it to them. But the question is for this court
wasn't the old common law punishment up to life in prison for robbery, and in certain cases capital punishment?
It was, Your Honor, and I actually believe there is a statute on the books, 18.2, it might be 14, that says you can't have death. There's no capital punishment except by statute. So I'm not positive, Judge Niedermeyer, but I know that the jurists in Virginia would understand that. And so, Judge Wynn, as to your question, can you have a common law offense that doesn't have punishment? I don't think we're in that situation, but it's very interesting because this court's decision in Hill versus Nicodemus relies on a Supreme Court of Virginia case called Wackwitz, in which they're looking at the common law crime of suicide. And by statute in Virginia, they specifically did away with the punishment for suicide. But the Supreme Court said that even that legislative act, specifically doing away with the entire punishment, is not sufficient to mean that the common law offense is no longer there. And so in Virginia, we have a situation where it is a crime, a common law crime to commit suicide, but there is no punishment on the books. And in 2014, 2015, 2018, the General Assembly has had bills to try to decriminalize suicide, none of which have gone through. So those cases, and this court's case in Hill, and also Brown versus Harris, which is at 240 F3rd 383, really demonstrate just how high the bar is to show clear legislative intent to change the common law. And I think Judge Niemeyer, I think it's worth saying that to say that we now have an extortion punishment that covers this conduct in 18-259, I don't think that solves it, because in common law, they knew that there was a difference of this version of extortion. I mean, they understood that this was different and worse, and so they made it part of robbery, which was a worse offense. And you have situations where they describe the elements of common law robbery before Houston without referencing this version. You have incidents where they reference common law robbery and the elements without referencing this exception between Houston and the 1930 cases. And then you have it to the present. I don't know that the fact that there is now a specific punishment statute for extortion shows any intent by the legislature or the judiciary to have intentionally carved out this version, this form of extortive conduct, and call it something different. And I don't.
All right, let me ask you this. Our ultimate goal is to try to determine whether Mr. White committed a crime of violence in the past. Question is, under your formulation, what are the chances that he committed a crime of violence by threatening sodomy? Looking at the elements of the offense and the fact of conviction.
I guess the question is, in the modified categorical approach, are there documents, or are we actually looking at what his specific conduct was?
The effort is to try to find out, without going into the facts of a particular case, trying to find out whether a predicate offense is a crime of violence.
I don't know that the
and
record.
The question is whether Mr. White committed a crime of violence. And I can tell you what I'm getting to is that this area is a difficult area because every state has a whole range of crimes. And they have all kinds of elements and innuendos and formulations about it. And the court has never said it has to be 100% or it has to be perfect. They basically said whether whether this man committed it is more of a percentages type of thing. In other words, they don't use percentages, they use another word. But the likelihood that he committed it. Now, we have undisputed evidence here that we have no record of this crime ever being prosecuted in Virginia. We have 4 cases as late as 1940s that refer to the formulation of England, and we have no recent cases that refer to that reformulation. And we have these 2 statutes that are one statute, 258. And the question is, ultimately, did this man, when he committed common law, when he committed robbery in Virginia, did he commit a crime of violence? And your argument is because there is that formulation beginning in 1890 about threatening to charge sodomy, that this guy therefore didn't commit a crime of violence. And I think, I wonder how we satisfy the demand to show that this man committed that crime, looking at the descriptions of this offense and how it's been prosecuted and how the jury instructions formulate it. We always look at those. We look at cases that actually been done. And of course, it fails on all of those. We know this man was not convicted. We know almost with a certainty this man was not convicted of robbery for threatening sodomy. So we're arguing this very intellectual academic point, which actually I enjoyed reading your brief on that. It went into it in quite detail. I sort of got sucked into it and thought maybe you should do an article on that. That was great, but I'm not sure.
I could piggyback on that. Mr. Jones, I've been practicing law in Virginia for, oh my gosh, 40 some years. And I have never heard this argument made. I think you deserve a lot of credit.
Well, thank you. But what I would say, Judge Niemeyer, just briefly, I know I'm 2 minutes over, is I don't want to cast it as a formulation that appeared in 1890 in Virginia, more as one that has always been in Virginia since its adoption of the common law. And I take the court's point, and I thank the court for its consideration of this. I do think that if the court is not inclined, certainly, certification to the Supreme Court of Virginia maybe very well be warranted given the federalism and comity concerns and how directly on point we are taking some pretty strong language from the Supreme Court of Virginia about what its common law.
One thing I want to be clear is that our analysis here is not under the modified categorical approach, because that's not been raised by the government, not even an issue in the case. It's the categorical approach, which you can slide into the other one, but it's not here.
That's correct.
And then when you get in the business of, well, it's never been done before, that en banc case we got, that Aparicio Soria case, is on point. I mean, that is there. If the state's highest court has spoken on it, we don't get in the business of saying, well, they've never done it before. Everybody knows you wouldn't do it. We've got to respect the Supreme Court of Virginia 4 times.
We also
old
have,
as it may be. It's still, if Virginia wants to do something with it, it's got 2 ways to do it: legislatively or by the Supreme Court.
We also have a bit of a blind spot, Judge Wynn, which is that the only way we would, I think, know about these cases would be if somebody were convicted on it and then appealed. And so I'm not aware of, despite having worked for a circuit judge in Virginia, of any way to retrospectively go back and identify the factual predicates for all robbery charges in the Commonwealth.
That's an interesting and good point there. I hadn't thought about that one, that we approach this as though just because we haven't seen a case on appeal or there's nothing written on it, it never happened before. I hadn't thought about that. That's a good one.
Yeah, Mr. Jones?
Yes, Your Honor.
If I could pile on, I think you've made a really good point here, because unlike so many, Virginia does not have an appeal of right at any level. And very few of the cases are taken on appeal. And so lacking an appeal of right, who knows what's been prosecuted?
Yes, Your Honor.
All right, I think we've covered the point very well. Mr. Jones, you're court appointed?
I am, yes, Your Honor.
I'd like to recognize that and thank you for your service to the court. Of course, that makes the system work, and we appreciate it very much.
Thank you.
At this point, we would come down and greet counsel. We'd probably give Mr. Jones an extra handshake for his service for this, but of course, Mr. Joseph, you're in a public service too, so we don't want to overlook that. We thank you for your arguments, and I'll ask the clerk to adjourn sine die.
This honorable court stands adjourned. Sine die. God save the United States and this honorable court.
All right, I guess we'll